We would appear to be live. I am in a right mess here. I've literally just finished working. I got the video done. I got everything I needed to do done. I'm now just going to find the stream. I'm going to use the PBS version. Yeah, people seem to think the Law and Order. I actually prefer the PBS one. But if we have problems, you can let me know. 1 second, people. Oh, what the fuck is that? That ain't meant to be open. Why have I got a map of Scandinavia? Lovely to see you all. I don't even know if you can hear me. Can I have an audio check and a video check? You're off, are you, Wolfie? Okay. Ta-da. What a shame. I've only just got here. Hang on. Let me get me here. Let's get the sound sorted. Yeah, sorry, people. I said I'd almost make it. We've missed a little bit of chat, but it's not of much interest. I haven't got into the big stuff necessarily at the moment. Share screen, share audio. Click that. Bosh that. Can someone tell me we have a result? Are we good? Can you hear me? Can you see me? Is the a computer program? Can you hear it all right? Cheryl Peters. Boom! Let's watch this within the Dangerfield community Megastream. Support the boy who defended himself against murderers. Free Carl. That's not my opinion. It's Cheryl Peters' opinion. Thank you, Cheryl. Much appreciated. All super chats and entropies appreciated. I'll sort out the entropy link in Una Memento. I think I can turn that off. Do us a favor. You can pop this link on your Facebooks or your Twitters. Maybe a good way to get some new people here. We got some new viewers. Always good to grow the channel.
It's my understanding.
I'll stop talking in a minute. Thank you, Cheryl Peters, for that donation.
The video program he uses is Amped, and Amped has internal
later
of everything
okay.
that the operator does on it. So
I just uploaded the work that I'd done, and I'm here. While it was uploading, I set this up.
My understanding is that there should be a report for that, and then the new photographs today. And our question comes into on testimony, on cross-examination, when he was testifying to what he did to the video. There's a definite discrepancy between the aspect ratios and the amount of pixels, so I'm asking for that report.
Well, we've heard all this bullshit before. Well, if you're new here or if you didn't see the last one, I don't do a lot of talking. There's,
so that we can.
I'll talk in the gaps.
Check that.
But this is so we can watch as a community and enjoy as a community.
Can or he can't.
I'm still doing a bit of work. Apologies. You've got a job in that. But let me sort out the entropy link. Go on, Carl. Go on, mate. It's a big day for you, my friend.
Examiner Armstrong's testimony is that he used a program known as Amped, A-M-P-E-D, the number 5. If he did use that program, Amped 5, which is a gold standard of forensic analysis, Amped 5 does produce a report of all manipulations or actions taken from the start to the finish.
So does Paint Shop.
That's the report I think we're talking about right now.
Okay.
That's very interesting that you should say that now. They're putting a lot in that. Thank you, Deadbeat Chess.
There should be at least 2 of them, 1 for each.
There you go. Special hello to you, mate. Well, I put 3 hours in before this morning's stream.
I don't believe where I have an obligation to provide that. This is a very late request.
Oh, hang on. This is interesting.
Push rebuttal into tomorrow because he's going to have to go. If these reports exist, that I am not saying that they do.
They do, you idiot. He's just testified in court.
You'd have to go back to the crime lab and get them.
Can you reach him?
I mean, I can certainly try.
Take you 2 minutes to email.
I'm not going to worry about anything till it happens.
It'll take 2 minutes. Thank you, Deadbeat Chess. Do you want me to sing for you?
Let's see what.
Let's see what. I don't even think you need to say Bingham, Matt. I mean, Binger. is a worse insult
Then
these
I
days
did
than
get,
Minger.
Mr. Binger's transmission.
You're all right, Chuck. You've
last
supported the
night,
stream loads. No one ever has to
which,
apologise. I know you're not apologising, but you know,
Was not.
it's a pleasure. It's a privilege to have you watching.
Was there?
Ah,
was
that's an
there-
insult, isn't it? What an insult
Other
to.
than the initial minute or two, was there actual video or was it black screen?
There was. It's like a 20-some minute compilation video with the defendant's voice.
State of that mess.
Well, let me try it. Let me try opening it here.
Binger's got an anus for a mouth.
At home, it was.
Yeah, we'll be
No,
looking at
I
closing
was
statements,
able to
people,
hear
if
the
you're
audio,
not
but
aware of what's
the
happening.
video was all black. So I don't know what the significance of that is until I look at it. Hopefully it'll open here.
But closing statements tend to be juicy as fuck, and they can be objected to. Strangely enough.
All right. Anything else?
Yeah, let the kid go.
I'm going to, I guess, forward an email that we just received a phone call from someone who supposedly spoke to.
Look at that suit riding up round his neck. Fucking hell, where did he get that made? Lidl.
That's great. I didn't mean to interrupt you.
I'm sorry. Just to be transparent, when we get these communications, we are giving them to the court.
Hello, Johnny.
And
Right, where was I? Entropy.
inundated, as you would expect.
Alan Bastard, are you about, my friend? I want a word with you.
Publicity
A
and,
good word.
all kinds of wild things are said, and as long as you folks are aware of them and can deal with it,
And don't fuck up again, Binger.
and I'm able to do it.
Don't keep lying.
I would hate to be someone who got caught doing some of this stuff. All right.
Don't tread on his Fifth Amendment rights to silence. Talk about a T-shirt that he wore 5 months after the incident. I'll get this grift sorted and out of the way while they're not talking at the moment. I will never silence this. So when it goes silent like this, that's the call. They turn the mic off occasionally. Oh, what happened to my thing? Hang on. Pin message. Message pin. Pinner. Right, while they're not talking, ladies and gentlemen, you can support this channel by becoming a member. You get access to private streams. I'm probably going to ramp them up. There's 2 hero streams this month for sure. Super chat is the $, which is down in the bottom corner. Sorry, Carl. Which is down there. The bottom of the chat. Entropy is pinned to the top of the chat. Or you can become a monthly subscriber on Subscribestar. If you do that, let me know and I'll sing your praises. I don't expect to get rich from this. I won't be getting the 40 grand that Rieka Law made every day this past week. And so he's justified in doing. He's got 6 legal professionals. But a couple of quid would be nice because we're going to be here for a few hours. And I just worked my nuts off getting here on time. Little bullet, nice one, mate. This is full on political. I fear Kyle hasn't got a chance. The left win practically everything, not the gubernatorials. This will be the biggest travesty in modern history. Bullet, I fear it, but I think what's on trial is patriotism versus communism. It's that simple. I mean, the jury won't call it communism, but it's maybe a more acceptable would be patriotism and the rule of law and the American way versus liberalism. So it comes down to 2 things. Are members of the jury patriots or liberals? If they're not strong with either of them, have they watched the evidence? Because the evidence, he's not guilty of murder at all. It's all self-defense. It's plain for the eye to see. So what I do think is on trial is the difference between patriotism and liberalism. Sorry, I'm still getting work messages, which is all right. But thanks for that donation, little bullet. Where's that one come from? Wendy's telling me I'm not live on the live feed. She says, No, no. So I'm being told by someone at work, weirdly enough, that this isn't the live feed. This, oh God, you might be right, actually. You might be right. 1 second, people. You might be right. Good call, actually. Right, sorry, people. Let's get this sorted out. Oh, yeah, we had that tie on the other day. How peculiar. So Yahoo have closed theirs. So this one. Sorry, people. How peculiar. My mistake, people. I was in a bit of a rush.
See, 245. I think it's testimony of accomplices.
Yeah, and that's a good model for it. That was what I had planned on using if I had drafted it myself.
Judge, I just don't think it's necessary. The evidence was received.
How amazing that someone at work is obviously watching this. It's Windy Willow, people.
Kind of instruction on this would essentially be telling the fact finders how to weigh the evidence.
Can anyone confirm that I've got the right stream
wording.
on, please? Hello, Woodlander.
You should
Tony's
not
betting a
guilty
retrial.
on it alone unless
Bit
after
of Jim
consideration
Morrison
of all
there.
evidence you were
Nice to see you,
satisfied
Tony.
beyond A reasonable doubt that the defendant is guilty is completely inappropriate. I can understand where it's appropriate if you're talking about accomplices, but
Where's
certainly
Windy
not
now?
when we're talking about a
Come on, Aidan. It's the kind of thing I do.
100 and some odd exhibits.
Can anyone confirm
so
I'm right?
I don't
Bigfoot's
believe it's
burner account.
appropriate. I don't believe it's necessary. I believe that these arguments about pixels and zooming are specious. That their expert used a very similar software program with zooming. With
Nice one, Windy. That's much
There was no
appreciated.
Objection, then you see that's
I understand.
my
Windy, my mother's coming round yours later while we're here.
Maybe they do. I don't know. I can't read their mind.
This is a forensically sound program used by a forensic analyst who's trained. This image is peer reviewed. If they want to discuss the proprietary algorithms and how a analyst would not know a proprietary algorithm contained in the software that they are using, that is an industry standard, they can go ahead and argue that. But to
Industry
give an
standard doesn't
instruction
change
that tells
anything.
the jury essentially to ignore this evidence unless everything else proves it is way too far.
Well, this whole business about
Pinch.
business, but
Pinch and
the
spread.
Daubert rule is the product of the abuse of so-called scientific evidence.
Excuse me, people. I usually wouldn't do this on stream.
There were companies, pension funds, individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage.
Amazing call by the judge.
Coming
This
here to
is.
tell me
That's amazing.
this is what they rely on. I think that's fine, except when my common sense tells me, well, wait a minute, what's happening here? When you get an image that is
Yes.
consistent of I don't know.
If I'm right, this is all to do with that crappy little bit of 2 pixels where the gun was
to
raised.
25,000 or 250,000, and you don't really know what fills the vacant space.
Excellent
that's a
for
little
Kyle,
struggle
this is.
for me.
Excellent.
And this is not being used to decide which camera I'm going to buy or which phone I'm going to buy when
Yes.
I'm in the store. This is being used to decide about whether someone's innocent or guilty.
Amazing.
So that's why I was.
This is brilliant.
When the witness answered, he didn't know, and the only reason I left here and I troubled.
Amazing. He's saying this.
And in the end, I decided, well, wait a minute, we allow this kind of thing to happen in DWI cases where the officer is. How does
Kaboom!
the machine work? I don't know. I just am trained how to operate it. But there
This is
a difference
massive.
there. That has already passed judicial scrutiny, and this method has been judicially determined to be accurate. Has
Massive.
that been done in this?
No.
I don't know. So that was when I was thinking, well, maybe I should give a cautionary instruction. I ultimately, you convinced me in our exchanges that I don't want to be meddling and commenting on the evidence.
But you
I'll
are.
tell you this, assuming that there's conviction, one or more, assuming that other motions don't contaminate the whatever outcome there is, if it comes out at some time that the method used produces unreliable results,
Wow.
this is going to fall like a house of cards.
Incredible. Incredible.
You're
Massive.
Basing this extremely important segment of the evidence on something that I'm really queasy about.
Wow.
As I said when I left here Friday, this is the jury's case. It's not mine. And I'm going to let them decide. They have your photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do. So I've decided to leave it alone. So I'm not going to give an instruction on it, but I've made my record on the high risk that I think it presents for the case.
Amazing. Amazing.
Okay, what's next?
The high risk it presents. That would have changed
The court
jurors'
had modified
minds.
a little bit. Count 6, which was the.
I did.
Okay, so the third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches. We have pulled the transcript, talked, and looked at it. Detective Antaramian was asked if this was a short-barreled rifle. He had answered no, he did not believe that it was. That's the only information regarding that.
Was the gun offered as an exhibit?
Yes,
That is evidence
correct.
enough in itself. The jury can measure it.
Okay. Fair enough. I just didn't, the way that I looked at it, there was no other information that a reasonable juror could believe that count 3's been.
Oh, really risky.
So
So what are you telling me?
then I'm asking that you take it from them.
You're asking me to dismiss the case for failure to prove.
This count 6. Judge,
Wow.
there have been many discussions about this count. I'm not going to rehash everything. The state disagrees with the interpretation the court has established. We do not believe this jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly raised. We argued about all that on Friday. I'm not going to rehash it. I believe it should go to the jury, and if the jury believes that it was not proven beyond a reasonable doubt, they can return a verdict on that. But state the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury.
That's just trying to get favour with the jury. He's not actually making a point here.
Well, up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these offensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately denied the motion to dismiss, although I think it ought to have been mighty clear that I had big problems with this statute. I've made no bones about that from the beginning.
Amazing.
And there always was access to the Court of Appeals all along here. Well, I guess that's not fair for me to say that.
This is all being very pro Kyle so far, really.
So shame on me. But
He wants Kyle to get off. He's a patriot.
I ultimately read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense,
He's basically saying he was reluctant.
but there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it, or you can stipulate that it does not meet what I've stated are the requirements. And if it is out of compliance, if the barrel length is less than 60 inches, or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel is appropriate.
Isn't legal?
It is not a short barreled shotgun or a short barreled rifle. Yes.
Shotgun. That's not me, that's them.
All right, and then count 6 is dismissed.
Standard AR-15's got a 20-inch barrel.
What's next?
One other thing, I had filed on November 8th, we had addressed a motion for mistrial with prejudice.
Thank you, Bigfoot, for your donation, mate. I'll read all the super chats out at the end, but I'll put them on the screen.
So I have filed.
And if there's time, I'll read them.
Something in writing on that. I know the
Tony,
court
that could
likely
be
hasn't had an
tomorrow,
opportunity to review it.
day after tomorrow. This is just
I
going to be
don't know.
final
I'm assuming.
summaries.
Okay. I'm assuming that we're going to go obviously through closing arguments today, but I did want to
Hey, Rufus.
make sure the court was aware that it had been filed,
Hayden.
and at some point have the court make a final ruling on it, just for the record.
I will.
Okay.
If it's necessary. Okay.
The prosecution are talking about fucking barrel
Okay,
length.
anything else?
That's where we are with this at the moment.
Defendant's interview link
I think
that we
so,
sent to
Henry.
play, the Washington Post story.
I did receive that. I did receive that.
It relates to the motion. That's the only reason I asked.
Desperate.
It relates to that.
Desperate. Sorry, I'm eating sweets because I haven't eaten.
Well, I'm not going to take up the motion now.
I just know there were technical problems. I just wanted to make sure they were ironed out.
I did receive it. Okay. Anything else right now?
Judge, are you done? Attorney Charles? Yeah. The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded AR-15 at someone without reasonable justification would be a criminal act without citing, the specific statute. But that pointing
Volume won't go up
under
any loud. I can drop
9.10
my
is
volume a bit.
crime.
Hang on.
We would like to point that out, and we just want to preview that.
How do I
So
do
if
that?
there's objection, we can handle it now.
You want to respond?
Who would object? This is once again relying on the exhibit that is so far out of focus, and there's been nothing in the record. When I specifically asked the Detective Howard, regarding the strong arm robbery, I asked about it. Strong arm robbery while masked. I asked about it. It's in the record.
The struggle I'm having with that is, and I will, well, I'll leave that. How do we know it was pointed at or toward?
Is it better if I just talk a bit quieter? Is that better?
You have a theory that
Is
it's
the
pointed in that direction.
is the volume okay for everyone like that?
But the statute's prohibition is pretty explicit.
I'll keep it down a bit, and I'll move the mic a bit. I'll move the mic a bit.
Evidence that you have,
How's that? Is that better?
especially the-
Good balance?
well,
Let me
not
know.
just especially, but in part because it's
Thank you.
just a
Thank you, Jeff. Cheers, story.
photograph. It's not
And thank you for telling me.
dimensional. It doesn't show the exact area.
I can only do what you helped me with.
Judge,
Even if you see the firearm.
again, the photograph is perhaps the fifth or sixth most relevant piece of evidence on this topic.
The most what?
Fifth or sixth most relevant piece of evidence on this topic. We have testimony, we have videos. I'm not going to go over that again. The defense submitted their own exhibit of the FBI video with the Zeminskis denoted as being
It's kind of stressing, right, Bullet?
that
It's
were
kind
on
of
that side of
stressing.
the Duramax. Mr.
Nice,
Zeminski starts out by one of the windows of the Duramax. I guess it would be the rear passenger side window, and so there's no real dispute that they are in that area, and that is where
How's that with the volume?
that he is pointing the
Can't
weapon.
really do much more
It's
than
for the
that.
jury to decide if he's pointing at Zeminski's or not.
So it's for the jury to decide. It is not.
Likewise,
for the jury to
Cheryl.
speculate. I mean, let's look at the statute. That's a good place to start.
Hello, Moslab. You all right, son? Thank you.
Was it 941.20? Yeah.
Yeah, it would appear so, Andy.
And that brings up, a separate issue, I suppose. That what is the role of Mr. Rosenbaum, assuming the defendant violated that statute?
Hello, David.
That's the very theory that the state has proceeded on in the first place, is that the defendant was a vigilante who was getting himself involved in something that was not his concern.
Nice one,
You're
Rex.
telling me that would justify Mr. Rosenbaum's actions? I'm kind of struggling with that too. How would that justify? I mean, how did the jury do with
Nice.
that?
Just like Cecil, yeah? Hello, Bushy.
I don't fully understand the court's question.
Cheers,
I would also
Gerald.
note
Is
that
Very kind.
he also pointed the weapon at Mr. Rosenbaum before the shooting. While he's being pursued, he turns and points it at Mr. Rosenbaum.
Well,
If I was the defense, I'd say,
Correct.
what, the paedophile? I mean, the
Pardon me?
defendant.
Is that he's being chased by him?
Exactly, Matt. I can't turn AGC. What's that? Fucking hell, can't keep everyone happy here, can I?
It used to be points or aims of firearm at another. I'm not seeing that exact language anymore, but
I'll just talk a bit quieter, okay? Until it goes crazy and he drops bombs. Thank you, Gerald. It takes effort to be nice.
Capture.
He'll probably end up being a news pundit, Jack. Nice to see you, Jack. You're right,
Some
son.
wrongfulness in just pointing the firearm towards the west.
Yeah, I noticed that,
without
Wolfie.
evidence that it
Good
was
to see you,
pointed
people.
specifically
I stream twice a day.
toward another.
Likewise, Madman, including the likes of Cenk Uygur as well, who said he went out to shoot black people twice after evidence had been seen. Shocking.
What am I missing?
1A is endangers another safety by the negligent operation or handling of a dangerous weapon. Sure. 1A is endangers another safety by the negligent operation or handling of a dangerous weapon. We would argue that it is. If the court feels otherwise, we just simply
No
talk
way!
about it and not
Check it
vote.
out, people. Check it out.
Say at the Zeminskis.
Great spot,
I
Billy.
didn't hear the Zeminskis come in here and say
I'll
that.
get my mouse on it. Son of Binger.
Except for looking at the video, and that's who's over there. That would be the only
I
other.
beg pardon?
Looking at videos and indicating that those are the ones who are over there, that would be the only evidence.
I can't say. I'm not saying it didn't happen. I'm saying I don't think I can give an instruction to the jury, telling them something when I don't see this statute.
Hey, Tony.
We're asking for instruction. In our closing, in our arguments, we just wanted to say that it's.
I think it would be okay for you to state what the law says, But you have to be careful because the jury
What,
cannot
that?
be invited to speculate.
That thing.
So I don't want to, you know, there's such a universe of possibilities.
I'll put it on for the laughs.
But I don't want to try to, you know, rule in advance. I've refrained from doing that. I always try to, because I can't read your mind. But so I'm not going to say that he can't mention that at all. That it's unlawful to point a gun at somebody. The jury's probably have a sense of it anyway. But as to what might be said, I can't tell you what's in and out of bounds. Okay, what's next?
Yeah, when Rittenhouse gets
Ready for the
off,
jury?
he should sue the
Probably take a
lot
break
of them.
after these lengthy instructions. And
What a surprise! They'll probably write whatever the ruling is. But they have lost so much public support, BLM and Pantifa. Be all right. You're going to be all right, son. You're going to be all right.
let's see.
Don't worry about the media. They're bullshitters. He looks terrified. Poor kid. Hello, Doc. Good to see you, mate. So that's not me silencing it. While it is silent, though, I'll do my best. If I can. I've got time. Son of Binger in the third row. Big Falls burner account said, "Hey Chris, here's a tenner for you. Been a minute since I caught the stream live. I think it's crazy to see all the facts coming out. The original self-defense narrative was exactly right, in my opinion." Yeah, I mean, it shouldn't have even gone to court. In a different cultural climate, it wouldn't have gone to court. But a white bloke shooting someone. There's still media outlets saying he shot black people, like yesterday. You know, and now they're lying by omittance. Some of the things I heard a woman on The View, and she said if Kyle gets off, it will put a message out to America that people who do this won't go to prison. And I was like, yeah. If you shoot in self-defense, you don't go to prison. What kind of comment's that? And that's a message it should send out as well. Self-defense, you shouldn't go to prison. As I've said countless times.
Okay.
Everyone who didn't attack Carl Rittenhouse is alive and has both biceps. That's a fact. If he went in his magazine, if he went out, he'd have killed 30 people easily. Standing on a roof, picking them off, headshots. He's grown up with guns. But he didn't. He did not go out to kill people. He shot people who smacked him around the head with a skateboard and held a Glock at his head. It's ridiculous. Even if he goes to prison, I have faith in this kid. I have faith that he gets out very early and makes something incredible of his life. Thank you, Anglosaurus. What did I say? Mittel. Absolutely, Jeff. It's huge. Absolutely huge. Yeah, I agree. Because it's you or them, isn't it? In that situation, it's you or them. If he hadn't shot that Pantifa in the bicep, and I think that geezer was lucky he didn't get one in the head, he would have shot Rittenhouse. He had a loaded Glock pointing at Rittenhouse's head. Rittenhouse pulled his gun up. The geezer put his hands up. When he put his hands up, Rittenhouse dropped the gun down. That didn't need enhancing. It's clear as day. When he dropped the gun, then the bloke got his Glock out, and so that's when he got shot. That one is just a write-off. He even admitted it when he gave evidence. Carl only shot you when you pulled your hands down and pointed your gun at his head, and he went, yeah. Oh, and by the way, I want 10 million off the state. Yeah, go fuck yourself. Maybe get a job or something. I agree with you. Bad influence. I agree with you. You know what, Carl? There's people on the media saying like that as if they're shocked. There's people saying that he's a hero.
We'll begin our final phase of our case.
I'd be proud to have him as my kid.
And I'm going to instruct you on the principles of law which you are to follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions, regardless of any opinion that you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only the evidence received during the trial and the law is given to you in these instructions. And from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as evidence against the defendant in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case. As to 5, and I might interject here, count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts. Self-defense is an issue in this case. As to each of counts 1 through 5, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference,
Did that get louder?
his beliefs were
That's all
reasonable.
for you.
The defendant may intentionally use force which is intended or likely to cause death or great bodily harm, only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person. A belief may be reasonable, even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offenses. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the standpoint of the jury now. There is no duty to retreat.
Got louder, good.
However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense, but the person may not use or threaten force intended or likely to cause death unless he reasonably believes that he has exhausted every other reasonable means to escape from or otherwise avoid great bodily harm. Counts 4 and 5 require intent to kill as part of the elements. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent to kill have existed for any particular length of time before the act was committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to have existed at the time of the act. You cannot look into a person's mind to determine intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. Proof of motive is necessary. While proof of motive is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The first count of the information charges that on or about
Hello, mate.
Tuesday, the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of another human being, Joseph D. Rosenbaum, under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances and the circumstances of the defendant's conduct
Yes,
showed
Lockwood.
utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors.
Hello,
What the defendant
Ben.
was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct. If, as to the first count, you are satisfied beyond a reasonable doubt that both elements of this crime have been proved, and that the defendant was not acting lawfully in self-defense,
He was.
as I have instructed you on the law of self-defense,
Hello, Ben on
then
CNC.
you should find the defendant guilty of reckless homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty on this
Good.
count. Counts 2 and 3 of the information accuse the defendant of the crimes of recklessly endangering safety. Although the elements of each of these charges are identical, the rules of self-defense which apply to them are not.
Thank you, Deadbeat Chess. Much appreciated, mate.
The second count of the information charges that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. The third count of the information charges that at the same time and place, the defendant recklessly endangered the safety of an unknown male under circumstances which show utter disregard. life. First-degree reckless endangerment, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances related to the conduct.
It's a bit butterflies, this, isn't it, people? Pow! One in the chat if you're a little bit knotted in the stomach. I'll start that ball rolling. I'm proper on edge. Not just because of the what this means for America, but also what this means for this poor kid. Hello, Skin Sky. You all right, son? Hello, King Corona. I didn't have an oval. Can you get an oval team chomp? That sounds like heaven. I might have to write you a song about it, Mr. Corona. Did you hear what Tucker Carlson said about Rosenbaum? He died how he lived, trying to touch a minor. Rosenbaum. I'm glad I'm not the only one who's a little bit. Hello, Mort. How are you, son? Hello, Lincoln Load. Nice to have you. Well, potentially, but if it goes our way, then, you know, that's... I think we're about to go on a winning streak. I think the gubernatorial races show that, and the midterms will be an absolute bloodbath for the present communist administration. That's Carl's mother. Looks like she's aged about 30 years, and understandably. She brought up a good kid. She brought up a nice kid. He was like a fire cadet, police cadet, learned how to be a medic. So sad. So sad. Okay, plenty of us. Yeah, I think so. I mean, I've been to court plenty of times on possession charges. I haven't had a conspiracy charge. Possession with intent, I got off because the old Bill nicked all the crack. Thanks, Gathers. I had my bags packed for prison. Turned up round. Oh, I'll tell you the rest of that another day.
When I was instructing you a moment ago on reckless homicide, I indicated there were 2.
Nice one, Fraser.
Actually 3. I did read all of the ingredients.
Exactly.
I'm just going to reread a portion of that instruction so it's clear that there are 3 elements to that crime. And I also use the word both of the elements, and it's actually 3. So I apologize for that mistake. And
Cheers, Fraser.
let's just we'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are,
As Ann Coulter
the defendant
said,
caused the death of another. He did so by criminally reckless conduct. And the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same three elements. So, utter disregard for human life is one of the elements of both crimes.
having judges getting threatened is like
and
something
in
out
order
of
to correct
Pablo's
on the
Bolivia.
First count,
Colombia.
we must find the presence of all three of the elements of first-degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense. Is that clear? Thanks.
I haven't got
Thank
a
you very
fucking
much.
Danny LaRue, mate.
Getting back to the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum.
Oh, steady on Simon Webb.
The fact that the law may have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life, but the defendant does not have a privilege of self-defense with respect to Mr. McGinnis. So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that.
Oh,
That doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him. However,
wow, that's not good.
You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. But he does not have a privilege of self-defense as to Richard McGinnis. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing
That's
at the time
interesting.
of the alleged offense. The reasonableness of the defendant's beliefs must be determined from
Nice ringtone,
the
Judge.
standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now.
So even if you think Carl made a mistake, if he thought he was endangered, even if he wasn't, that's still self-defense. That's very interesting.
You should consider the evidence relating to self-defense along with all the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Joseph Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove the burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. If, as to each of these counts, you are satisfied beyond a reasonable doubt that the elements have been proved and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of reckless homicide of the first degree. If so satisfied, then you must find the defendant not guilty.
Good. It's the beyond
Fourth
reasonable
count of the
doubt.
information charges that
that
at the same
works,
time and
Kyle.
place, the defendant caused the death of another human being, Anthony M. Huber, with intent to kill that person. This is a charge of intentional homicide of the first degree, and you must consider first whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of first degree intentional homicide, you may consider whether or not the defendant is guilty of second degree intentional homicide or first degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second degree intentional homicide and first degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant have caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant have acted with the intent to kill. First degree reckless homicide requires that the defendant acted recklessly and that the circumstances of his conduct showed utter disregard for human life. It will also be important for you to consider the privilege.
He
of
was
self-defense
running away from
in
them.
deciding which crime, if any, the defendant has committed.
He was running away.
Self-defense, the Criminal Code of Wisconsin provides that a person is privileged
Hello,
to
Livy.
intentionally use
Hello,
force
John.
against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his own person by the other person.
Without a
However,
doubt.
he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself.
He'd
As
already
applied
had
to
it.
this case, the effect of the law of self-defense is the defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his own person, or reasonably
100%.
believed the force used by him, and reasonably believed that the force used by him was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second-degree intentional homicide if he caused the death of another human being with intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide.
What was he meant to do?
if he
Spit on
intended
them?
to cause the death of another with the intent to kill and did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of another by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life.
The whole beyond reasonable doubt is what makes this
You will be
case.
asked to consider the privilege of
work
self-defense
in
in
Kyle's
deciding
favour.
whether the elements of first-degree reckless homicide are present.
That's interesting,
Because the
Ariel.
law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established
No, Jack, but
necessary
he
facts to
said he was
justify
going to kill
finding
him.
guilty for first or second degree intentional homicide or for first degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The
I
facts
keep
necessary to
moving,
constitute
Gaffney.
each crime will now be defined for you in greater detail. First-degree intentional homicide is defined in the criminal code as committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that his act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Third, that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of the first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's conduct, when first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another with the intent to kill, that this is Mr. Huber, with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. If you are not so satisfied, then you must not find the defendant guilty of first-degree intentional homicide and must consider whether the defendant is guilty of second-degree intentional homicide as defined in the criminal code, which is a lesser included offense of the first-degree intentional homicide.
Let's be honest.
There are hierarchies of cases in the law.
Let's be honest. I don't think any of the jury really know what he's talking about. They're gonna say you're going home or you're going to prison.
That are of the same nature with many common elements, but some differences. So there's a sequence of verdicts that are going to be submitted to you with respect to this count, and that's what we're going through at this time. So we'll take on now the but let me advise you, you should make every reasonable effort to agree unanimously on the charge of intentional homicide of the first degree before considering the offense of second-degree intentional
I
homicide.
didn't get a chance to eat today.
If after a full and
I'll turn my mic off, though.
consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of intentional homicide of the second degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Second, that he acted with intent to kill another human being. And third, that he did not reasonably believe that he was terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. These same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force which was used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved one of the following. First, that a reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm, or that the reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the standpoint of the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, and did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide as defined in the criminal code, which is also a lesser included offense of first-degree intentional homicide. Again, you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide, which is a crime committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before the defendant may be found guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct, which means the conduct created
Like someone else said, Jack, I think they've probably already made their minds up, you know.
Death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk.
I think the time they take deliberating will be lip service.
You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created the unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to establish beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous the conduct was, the obviousness of the danger, whether the conduct showed any regard for life.
Henry, they've done a Blair on Scotland, haven't they? They've done a Blair.
The evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense.
Good call, Craig.
And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death so as Consider also the defendant's conduct after the death, to the extent that it helps you decide
Yeah,
whether
they're
or not the
vile,
circumstances
Dillage.
showed utter disregard for human life at the time that the death occurred. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that the defendant's conduct was not privileged under the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree, as submitted. If you are not so satisfied, then you must find the defendant not guilty.
Carlson, why can't I find your super chat?
The fifth count of the information charges that at the same time and place, the defendant attempted to cause the death of Gage Grosskreutz with intent to kill that person.
He'll be
A
missed.
crime of attempted first-degree intentional homicide.
Hello,
With
Eunice.
respect to this charge, you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional
I agree, Henry.
or first-degree reckless endangerment, which are less serious degrees of criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide are different degrees of homicide. Again, that is the taking of a life.
He also celebrated Veterans Day,
The degree of attempted homicide is defined by law.
and his previous phone ringer was interesting.
While the law separates intentional
Nice one,
homicide
Carlson.
into two degrees, there are certain elements that are common to each. Both attempted and second-degree intent, both attempted first and second-degree intentional homicide require that the defendant have intended to kill another, that he did acts towards the commission of that crime which indicate unequivocally, under all the circumstances, that he had formed that intent and would have caused the death of the other, except for the intervention of another person or some extraneous factor. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any.
The Covington kids made a few million, though, Donnie.
Criminal Code of Wisconsin provides that a person is privileged.
They've all turned off,
intentionally
Dennis,
use
long
force
time ago.
against another under the following circumstances. Force is used for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his own person or by the other, and he uses only that.
No, he's a
amount of force
patriot. He's
which he
proven
reasonably
that.
believes is necessary to prevent or terminate.
I hope so, Moslab.
And the person may not and the person may not intentionally use.
I'm turning the judge down a little bit because this is just repetition. One of the nice things about being on a channel like this, rather than one with 1 million people watching, is I am trying to get relevant comments on the screen. It's nice to see so many OG scrubs on the firm. It's nice to see some new people. It sounds like it beef based. It sounds like the same page again and again. He was running away from them. No one gets shot if he didn't get smacked around the head by a skateboard twice and the other geezer didn't pull his gun on him. Simple as that. John, that's not fair. John, they set him free.
He is guilty of attempted second-degree intentional homicide if he actually
How are you, mate? Yeah, that's a good call, actually, Albert. I'll turn this back up when this same two lines has been said another 1,000 times. But I do think that the whole beyond reasonable doubt works in Carl's favour every time.
You will not be asked to make a separate finding as to whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has proved necessary facts to justify a finding of guilt.
But Al, I think if a jury member felt like that, they'd speak to the courts. I honestly do, because they'd say, look, I can't do this because I'm too scared. And there are processes in place for that kind of thing. Hello, Flamadid. Look, even if he goes away, I don't think he does a long stretch, and I think he'll do well, and I think he'll come out and there'll be GoFundMes, but the ones that you can have for conservatives and right-wing people. Nice one, Ian. He displayed better gun safety than Alec Baldwin.
Another person means anyone other than the defendant, include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control.
It's just very repetitive, Al.
Element is that the defendant did not actually believe that the force used.
Let me
was
turn my
necessary
fan
to
off.
prevent
That
imminent
might be
death or
making
bodily
some
harm.
unnecessary noise.
The third element of attempted first-degree intentional homicide requires that the defendant did not actually believe the amount of force was necessary.
I'm turning it down again. It's the
to prevent
same
imminent death or
same old nonsense. We might as well talk amongst ourselves. There you go. That's what Tucker Carlson said. Rosenbaum died how he lived, trying to touch a minor. Be careful, Brian. They'll have your account for that, mate. Nice to see you. You all right, son? That's a great point, actually, Giles. Was Rittenhouse supposed to consider all this as he was laying on the ground? Well, this is why you have to get a lawyer, isn't it, Ariel? Because I understand that law is complex, but this is a foreign language. It's a foreign language. You think so, Dennis? He could just say, as I previously said. Moslab says there'll be more than one patriot on the jury that will stonewall this into a mistrial if need be, but I think the jury will do the right thing. I think this is what is on trial here, figuratively. Patriotism versus liberalism. Because liberals don't believe in the Second Amendment. They want guns taken off people. They don't support anyone having them. And patriots do. It's kind of that simple. Hello, Aldo. Good to see you, mate. Yeah, be terrified. Innocent on all counts. Let's go home. Oh, as I said before. He's literally reading all the same stuff out for every single charge, right? That's what I want to see, Andrew. I want to see the lying mainstream media and that lying big fat brown buffalo Yuga get hammered. Third element of attempt to second degree intentional homicide requires that the defendant did not reasonably believe that he was. I mean, all these mainstream media, what did they just expect him to lay there while they pummeled him with a skateboard, kicked the shit out of him, and shot him with a Glock? Is that what he should have done? Is that the right thing to do? You can argue that he shouldn't have been there or it was dangerous, but that's not what's on trial. He's not on trial for making a bad decision. Feels like that, doesn't it, Rex? Likewise, Brian. I need a new computer. I got some very substantial donations the other day, so I'm waiting for Black Friday. That's a great point, actually, Moslab. Better to be judged by 12 than carried by 6. Absolutely, Daffy. Good to see you, mate. Hope you're all right. He would be dead if he hadn't shot him, or like you say, spasticated. For people who've just joined us, we've turned the court microphone down a bit because this is one hell of a repeating. It's just legalese for the last 20 minutes. Westo says, can he repeat that? I went for Lou, wouldn't want to miss any. I'm reading them out because some people have got this on audio only. Hello, Sue Fist, you all right, son? No, they don't. They don't know that they was a pedo, a wife beater, and a burglar. Unfortunately not. Steady on, Fat. Steady on. Watch yourself. Do you know what I mean now? But if my great uncle had known how this would play out, he'd never have stormed those beaches, or at least without the same enthusiasm. Imagine bringing them blokes back to America or England today. Yep, you certainly protected us. Yeah, it's lovely, isn't it, Dennis? Because everyone gets to get a say. And I'm not being selective. I'm just putting comments on the screen that are relevant to everyone, rather than conversations or poor jokes or good jokes. No, I understand that, Moslab. He's got to do it. This is how law works. It's just a little bit frustrating because, you know, it's got beyond itself. It once upon a time this made sense, but as law has developed, it's just got, you know, it's almost like hypertrophied law. Hello, LC350. Good to see you, mate. Here we go.
Consider the charged offense first. If you find unanimously the defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense.
He's forgotten. He's as confused as us. Look, looking into space, 2,000 yards stare. Come on, wake up. Look, he doesn't know. He doesn't know. This isn't good.
I've got myself into a mid-sentence and I don't like it.
Me neither. Court microphone will drop out now. It ain't me. There you go. Yeah, Eldritch, hello, nice to see you. I think it's all about beyond reasonable doubt. I think that's what's going to, I think that's that's the fulcrum upon which this whole case swings on. Will Martin says, when's the verdict? It depends how long the jury take to deliberate. You know, these things can go on for days, they can go on for 30 minutes. And, you know, let's not forget, when OJ got off of blatant murder, it was only 3 or 4 years later that black jurors were happy to go on record, on video, you can go and see them online, and say, no, we just wanted him to get off. We wanted the black man to win. They said that. So, you know, these are the kind of things you're dealing with. We're dealing with humans here. The idea that there's no bias is ridiculous, but there isn't just 12 jurors. I think there's 18 and they select 12, don't they, for a little bit further down the road. Not further down from here, but along the process. I've just caught up with the Tony thinks the left will call a retrial. The media will definitely ask one if he gets off, but it's not up to him. Yeah, but that works both ways, Grego. I mean, it does only need one blue air to fuck the unanimous verdict, but it only needs one sensible patriot to fuck it the other way. Look at Rittenhouse, he looks terrified. He's a child, and he's a very young, he's not a mature 18, 19-year-old, is he? 12 skeletons sitting in the jury box. 3 have already gone, have they?
The concern that I have, and I worked with the instructions.
Hello, Alan. Good to see you, mate.
All weekend, and we discussed them by email, and then I'm reading them, and little things are striking me as I read them.
You sure? No one else is complaining? Anyone else having problems?
Except in the context of charged offenses. And what I was about to say to the jury and decide.
He was when it happened, but I think he's 18 now.
The jury gets into a discussion of a charged offense. Any charged
Mail-in. Mail-in jury verdict.
And they decide that
That's interesting.
The elements are there, and he wasn't acting lawfully in self-defense. They're done. They never discuss the lesson. What?
Thank you, people.
Well, let's say if they decide the elements are there, but he
Thank you, people.
was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime. What if they discuss count 1 or count 5, I should say, and decide that the elements are there, but they all decide it was privilege under the law of self-defense?
Thank you, Alan.
They're not. Is there anywhere that they're being told? Are they being told?
Much appreciated.
See, under the old law, we did do that. Is that in here? Where is it saying that?
Oh, fucking hell.
I used to construct these from scratch.
Thank you, Alan.
I would tell the jury, which I was just doing now, that, once you have exhausted this, you're done. As opposed to having them needlessly go through.
Yeah, but Don in armor, when you're my age, 18 is a child.
And this is a case
and he's a very young 18 as well.
I'm saying it could, that they would decide, well, the elements are there.
Too much talking on their Baz.
All of them say, well,
there's nothing wrong with this stream.
On the basis of
don't get brazen with me.
Then they really should not be considering lesser included. Am I wrong about that?
All right, Liam.
So if
Depending on
perfect self-defense on the charged count,
Yeah.
they should be told.
You see what this? Yeah, I'm sorry.
I understand where the court's coming from. I guess they could consider the other ones in 30 seconds and just go down to be not guilty. But
objection. Come on.
Yes, it is. No, I understand. I feel terrible about doing this kind of stuff. It's just so. Well, anyway, see what the instruction is telling them, that kind of cryptically. It says it tells them if after a full discussion.
Depending on the verdict is what emojis I'll make up for members. If you want to support this channel, you can become a member. You get all the emojis. members bung some emojis in the YouTube chat. He looks about 14, doesn't he? What I mean by young is he's not going to do very well walking around Hackney at
Says,
midnight.
however, if after a full and complete consideration
Hello,
of the
Packer.
evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, I'm going back to a different count, you should consider whether the defendant is guilty. So it is telling them.
Hello, Bangers and Mash.
Yeah, I just think it's kind of unclear.
I think it's very important. What you're saying is wrong. They all agree that the elements are met and there's a privilege. You don't go any further.
Perfect.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously agree, which includes the privilege, they're done. They don't have to go forward.
Where does it use? It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So, there, I don't think it's
Clear.
That's not the way a person would speak if he wanted to make things clear. And
Exactly.
I'm not saying anyone deliberately is trying to make things unclear, but
Thank you, people, for the emojis.
don't do that. People will find out our lawyer secret.
Oh, hilarious.
Clear in the instructions. If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count, there's no need to go to the lessons.
Yeah, I think that's a good way of doing it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count, if they are unanimous either way, then they're done. Does that make sense? No, Mr. Binger's having a problem with that, and let's see where he is.
Binger.
I don't like the way I said that either.
One other person complained, but many other people said it was fine. I mean, you know, this is how the internet works. Some people will have a bad bit, and that'll get better. Weather affects it, and there's a fair amount of different weather. But there's still 152 people watching, so I imagine it's going okay. Rags has got jeans older than Rittenhouse. I bet you've had them on that long and all. Oh, it's rough as monkeys down there. I used to have to go and score down there, which means you couldn't fight your way out of a plastic bag or a paper bag at that, even a paper bag. And it's not great. What an horrible place. I mean, so beautifully enriched. Fucking hostile as hell. What a place.
In any count.
Good call, Carlson.
Multiple verdicts submitted to you.
Nice one,
Point
Baz.
in your deliberations, you are unanimous as to both the elements, presence or absence of the elements of the crime, and the presence or absence of the right of self-defense. You need go no further.
Well, hopefully Rittenhouse will get his white privilege card out in a minute. I've been waiting for it.
Let's take Anthony
Fuck off,
Cooper's
Binger.
counts, for example. If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
Only if they're not satisfied that it was.
Not in England, he doesn't, Leon.
If they, for example, if in your example, if they discussed it and said, well, sure, the elements of attempt murder are there, and then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's, well, actually, if they all say we don't think it's self-defense, then it's not guilty. And what the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
It says if you are not so satisfied.
I know it. Well, that's at the very end.
And
I don't like this because Binger's a snake.
Unanimous on
Binger's a snake, and he'll be using this to try and swing it.
go no further.
I like that.
That's not the law.
If you're unanimous on,
So, for example,
if you're unanimous on the legal question, intentional. Well, you're right, because it could be an elements issue.
the jury
Maybe the constructions committee is right. I don't know.
the jury only goes to lesser included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count. Then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous.
Yeah, I'm not
If they're
finding.
unanimous-
I'm not finding that.
If they're unanimous, then they're done. That's what I'm trying to tell them.
It's
But I don't
very
understand.
unpleasant.
That's not true, because if they're unanimous on first degree intentional homicide, what they're concluding at that point is that the defendant, either the elements aren't met or the defendant actually believed that deadly force was necessary. They would still then have to consider the second degree intentional because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first degree intentional homicide. They can be unanimous on that and in the defendant's favor, but they still have to then move to the second element. Or to
It
the lesser
feels
included.
like that, doesn't it, Bullet? Say
You're
something, defense. Say something.
If it's perfect self-defense, it's perfect self-defense for everything.
They're not
Yes.
told to consider perfect self-defense on first degree intentional homicide. They're specifically told
right. Well, yeah, you're right. He's right.
Oh, this isn't
consider that
helpful.
until
Thank you,
second
little
degree
Bullet.
intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But
Maybe we could.
I'm sure we could. But we need to follow them, and I don't
Well,
think deviation is
you're
appropriate.
right. I think you're right.
That's not helpful.
They're certainly correct in what they say. I just think that they're not clear. But maybe they are. I don't know. Now let's see how much damage I've done already by my last paragraph. So can you go back to what the last thing
Fucking
I said on the jury?
hell. Damage to who or what? Fucking hell. Let him off, please. Dear God. Okay, not a problem. I'll stop shouting again. I'll move my microphone again. Is that okay? Audio balance okay now?
Defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, and then that's when you stopped in mid-sentence.
Oh, I thought you was going to say the same thing about
The
that.
first part was right. Did not commit the greater crime and was acting lawfully in self-defense. You know, if he was acting lawfully in self-defense,
Ignore the rest of
ball
them.
game's over.
Yes, yes, yes. Say that. Leave it there. Sorry, I'm shouting, but yes, leave it
I
there.
think that's correct.
Yeah, we're going to go with that.
Your suggestion is seductive, Mr. Binger.
Fuck you,
But,
Binger. Excellent.
But see, they're not asked to consider that. That's where I'm having the problem. And they even make reference to it. I think maybe I read one of the comments. They talk about we don't have, like some states do. They have a question right off the bat: was the defendant acting lawfully in self-defense? If they answer that yes, we're all done. We've got it interlaced in all these cumbersome instructions.
No, you have. I certainly have
Does
read it,
anyone have any
Albert.
objection to what I've already told the jury?
He never finished it, did he, Albert? I think he died.
And tell them what?
Just what we said.
Summarize that last point.
If you find perfect self-defense, you don't go on to the next count.
Perfect. Yes. Fuck off, Binger.
Perfect self-defense means, but we haven't told the jury what that means.
Oh.
We're deviating from the standard instructions here, and the words perfect self-defense don't have a meaning to ordinary people, would require further definition from the court, and now we're going much further afield. I also have a problem with the wording of, if you find the defendant is justified in his self-defense, because we've instructed them on his own
Look at Rittenhouse's mother there, look,
self-defense
terrified.
belief, which is a defense to the first-degree intentional homicide. And then we've given them the instruction on what the law considers to be objective self-defense, is what a reasonable person would think. When the wording that was just read by the Madam Court Reporter
Wow,
doesn't
Billy.
delineate
Shocking.
between those two things. And I think, as I said, and I've repeated here several times, I think the more we deviate from these standard instructions, the more confusion it causes.
How's the audio
Counsel
balance
has
now?
asked you to read the self-defense individually on each count. So they're already being told on
Hello,
each
Chris.
count that you are to consider the final thing is the objective self-defense.
Hello,
That
Colonel
is
Custard.
if you find that, then he's not guilty.
Yes,
And
Rex.
to say across the board that you find self-defense is a defense to everything is not technically true, because there are different self-defense claims as to the different counts. So, for example, he may be justified to self-defense as to Rosenbaum, but not as to Huber. So,
Don't get brazen with me,
anytime you
Binger.
find justified self-defense, he's not guilty, is not technically true.
Well,
So, again,
it is if you're talking just about an individual count.
But I was saying blanket.
And I think what I'm going to tell them, in addition to what I've already said, is if they
What a Binger.
are discussing any count that has
Not
multiple
really.
possible verdicts.
I think the standard instruction already spells that out, Your Honor.
Is that any better? Is that a better balance? Is that better? Is that better? Is that
Deviate
better?
any further, because I think it's causing confusion. What Madam Court Reporter just read back, for example, could be construed as saying anytime.
Hello, Charlie.
Any count. you
A lot of
find
legal
justified self-defense,
beagling, to be
he
honest
walks
with
on
you.
all 5 counts, and that is absolutely not true.
That's not what I intend to tell them at all.
I know you don't need to tell that, but what's already been said gives that implication. And again, I just worry that the more we deviate from these standard instructions, the more we get into these issues. I think we should stick with what you drafted, which has been sent to the parties. We've all agreed on them. And
Oh, I wonder why.
am leery of any additional language that hasn't been cleared by the parties and could cause further confusion.
Well,
Thank you, Ian.
and whenever I've dealt with lesser included, I do give a little talk about how they should address them. And this is a more complicated case than most.
For people who haven't been to the Old Bailey or other serious courts and other in America, a lot of judges are like this. This isn't unusual. They're a lot of the time they're very old, they're very batty. I've seen this sort of stuff countless times.
Statement about if everything's present, they're done because they found the defendant guilty.
And actually, it's not necessarily a bad thing, because there has to be a bit of flexibility, because it's not a one-size-fits-all, but it can be very frustrating.
In self-defense.
Thank you, Ian.
Instructed on that. So I think the correct statement is, if as to any of the cases with multiple submissions, if on any individual count, they find
Say it. The defendant not guilty. He's not guilty on
consideration
all.
of the charged offense, that the defendant acted lawfully in self-defense.
Yes, go on. Yes, that's massive. This is massive.
Any objection?
Amazing.
While we're talking about the jury instructions, it was noticed as you read them
Oh.
on page 10, which is count 3, it should be first degree reckless endangerment, and it's written and you read homicide, which is not a homicide count. So
On page 10,
Fuck
on
off.
page 10 on count, still at the end of count 3, it says you
Bad enough being Binger, but imagine being his bum boy. Good lord.
we didn't catch that last night when we talked about him. I sent you 3 drafts.
It's a shut up.
But you know what? Should I just leave that alone? They'll know that. I'll change it in the printed copy.
Thanks, Rags. Thank you, Westo.
Everybody thinks.
Just let me know if the volumes go out or I'm shouting, you know. Just trying to do my best in difficult
How
situation.
are you going to talk in your first sequence?
Trying to limit myself to 2 hours.
What?
Are you troubled by taking a break in the middle of your presentation? Well, let's just kind of plan on around noon.
Sorry, Otto.
So, and I'm not going to comment on the lunch.
Hello, mate. Good to see you, 21st.
So let's ask the jurors to come back in, please. So I'll take a break why don't you around whenever you're comfortable, around noon.
Here we go, people.
Just ask for the break.
Here we
Yeah.
go.
Well, when he's the commander of I don't want to interrupt him at a time he doesn't want to be.
If I do shout or scream, I'll try and point over this way because it's difficult balancing all these volumes when you're a boomer. Hello, Shane. Hello, Loki. How are you, mate? Yeah, I think we done well out of that, though. I think what they've said is if they find he acted lawfully in self-defense on one case, that's it. It's done. 2 hours of Binger. But it might be interesting because Binger's got form for breaking the law.
So, folks, what I was talking about with
In
cases
court.
that you have multiple possible verdicts submitted to you for consideration, when you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense, you're done.
Right.
Return a not guilty verdict without considering the lesser offenses.
So you didn't need to read those 35 pages of nonsense
It
there.
hopefully will become clear. I'm going to give you written instructions because I know this is arduous going through this, but every bit of it is important. But you'll get written instructions for your reference in considering these things.
Well, it wouldn't have been a strike, Andrew. It would have been a copyright match. So I doubt that it got a strike for it.
It's 1 through 5. That's all the counts now.
But thanks for
Each
the warning.
contain the guilty verdicts of any submitted offense.
Respect to you, Custard. Respect.
Based upon the allegation of the information that the defendant committed the crime while using a dangerous weapon.
Hello, Greg.
If you find the defendant guilty on any of the counts, you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you may find answer the question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, then the question must be answered.
Well, maybe the size of my channel might keep us under the radar.
In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not.
People, if I do get yeeted, it's only for like 4 minutes, and I'll find another stream and I'll be back up. So if you want more of it, you don't need to go anywhere. But it like YouTube does yeet you for about 4 minutes.
By evidence, which satisfies you beyond a reasonable
Thank you,
doubt
21st Dissidents. Appreciate it.
the burden of establishing every fact necessary to
200 on the firm. Thanks for coming, people. I stream twice a day, every day,
the evidence must
until my
satisfy
missus is
beyond
here,
reasonable
and then it's
doubt
once a day.
that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason may be
Spitter.
given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A
Unhelpful.
reasonable doubt is not a doubt, such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt.
Excellent.
Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who called the witness.
Oh, how
Second, any
interesting.
exhibits which have been received, whether or not they accompany you to the jury. Third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find.
What
Anything
is
that you may have
what
seen
is
or heard outside
Rex?
the courtroom is not evidence.
You're the only one complaining about it.
On the evidence offered and received at this trial.
I know, Rex.
You should
Amazing, huh?
disregard entirely any question to which I did not permit an answer. Do not guess what the witness's answer might have been, and if the question itself suggested that certain information might be true,
So they're closing down. They're probably closing down, non-mainstream media coverage
improper questions asked of witnesses and to the
because they're communists.
belief is not properly admissible. You should not draw any inference or conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. At the beginning of the trial, I described the charges against the defendant, counts 6 and 7, which respectively charged possession of a firearm by a minor and curfew violation.
Hello, Duckboy
Have been
Jordan.
disposed of and are no longer part of this case. The other counts remain. Do not guess about or concern yourselves with the reasons for these dispositions.
I can't do
This
it
may
now.
affect your consideration of the charges that remain. Do not consider evidence that related only to the counts which have been disposed of.
Not now.
During the trial, I have ordered certain trust testimony stricken, and you must disregard all such stricken testimony. Exhibits become evidence only when received by
No, Ian.
an exhibit which was marked for identification but not received is not evidence. Whether or not, excuse me, is not evidence. An exhibit received is evidence whether or not it accompanies you to the jury. Remarks of the lawyers are not evidence, and if the remarks suggest certain facts not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the attorneys, but their arguments, opinions, and conclusions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict upon the evidence under the instructions given you by the court. I have taken.
If people watching this are interested in reading, I do have a Substack. I write true stories about my life. I've just put the link in the chat, but it's also in the description. There's about 12 stories in the archive, and you'll get another new one every month. So if you like reading about the dirty, rotten, greasy underbelly of life, that might be something for you. It's totally free. I'll never monetize it. Check it out.
Ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all other evidence in determining how much weight, if any, the statement deserves. The weight
Oh
of the
my
evidence
God!
does not depend on the number of witnesses on each side.
That is insane, RMF, that they just killed. He has about 40,000 people watching. Shit. Well, we might go soon, people, but hang out 4 minutes. I'll find another stream, even if I have to find a stream that isn't on YouTube. Girlfriend's on the blower. I'll mute it. But they'll come back in 4 minutes if they shut them down.
Yeah, to know and observe the matters and things about which
Sorry,
testimony was
people.
given. The reasonableness of the
I
witness's
had him
testimony,
turned down.
the witness's apparent intelligence, bias or prejudice, if any has been shown, possible motives to falsify.
Yeah, I
and
muted
all
the
other
judge.
facts
Sorry,
and
people.
circumstances during the trial which tend either to support or to discredit the testimony, and then give the testimony
Sorry about that,
the
people.
weight you believe is
A
entitled
mistake
to
was
receive.
made.
The defendant has testified in this case, and you should not discredit his testimony just because he is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of other witnesses. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and
You're all right, mate. Sorry that you're having
everyday lives. You
problems.
determine for yourselves the reliability of statements made to you by others, and you should do the same thing here. Evidence has been received that 2 of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon their character for truthfulness. It must not be used for any other purpose.
I think so, Albert.
We're going to hear the closing. You know what? Does anybody want a break, even just a short one, or not?
I need another piss. Hello, Kieran.
Okay, we're going to hear the closing arguments of the attorneys now, and they.
Right, so here comes the big guns. Sorry about my little mistake with the judge back there. I'm doing my best, people. I'm doing my best.
Format in the court, that is that the proponent of a proposition is entitled to give the first and the last argument. So Mr. Binger will address you first on behalf of the state.
Isn't it weird that YouTube are only shutting them down now? All week, everyone's been streaming this. They're just doing it today. They're such fuckers.
On behalf of the state in rebuttal, limited to rebuttal of things stated by Mr. Richards during his presentation. The break, obviously, I'm not going to make you sit there for 5 hours, unless you watch it. So we'll break. I asked Mr. Binger while you were out of the room if he was comfortable with breaking his argument in parts, and he indicated he was.
Good.
So at a time he thinks is appropriate, around noon, we'll take our lunch break.
Mad that they're just doing it today, innit?
And pick up this afternoon, and after all of the arguments have been presented, I'll give you about 3 or 4 more minutes of instruction.
Fucking
and
hell.
then we'll do our striking with the tumbler over there, and it'll be yours. So
No, of course, Ian, I understand, mate. It's only throwing bollocks at you.
which one do you want? The sister's pointer? Okay.
Like I say, if it does get yeeted, it'll be 4 minutes and I'll be back with another one.
We'll take a vote right now. Supposing the case arguments are finished at 4:30.
Good call, Al.
And we'll be working well to get there. How many would like to begin their deliberations tonight and stay until?
Yeah, there's no snow here either, Cheryl and Moslab.
Would like to come back and start fresh in the morning.
Oh,
And the
no.
cutoff point would be, say we got finished by 4, and I give you the case.
Yeah, I feel like that, John.
The latest I would let you go if you didn't want to stay late would probably be about 5 o'clock.
You nailed it, Broken Silence.
And so I don't know how much you can get done, but you'd have the option to get started this today, or we just start fresh in the morning if we finish up anytime after 3
Wow.
hours, 4 o'clock. So how many would want to continue on today?
I mean, Recreator gets like 30,000 viewers.
5,
I think what Broken Silence said is the truth.
7,
They're expecting not guilty and they don't want it publicised. Why else shut it down today?
Fresh tomorrow.
People have been streaming this the whole trial with no problems.
But
They're so transparent,
okay,
these
of course,
bastards.
as always, I'll make the final decision, but I certainly will try to follow your wishes. So, okay, with that, Mr. Minger, it's yours.
Well, I think so, Liam, yes. Well, I need
morning,
another
ladies and
piss. I've drunk
I want to
a
assure you that everything that the
I've drunk
judge
that.
just read to you, you'll get a copy out, so you'll have a chance to look it over yourself. You don't have to memorize everything he just told you.
Don't smile, no one likes
I
you.
think it's no surprise that this is a case that there's a lot of noise and a lot of static surrounding it.
So what I'd like to do at the beginning is crystallize it in a nutshell for you and keep it as simple as possible.
Whoa.
This is a case in which a 17-year-old teenager
Sorry, people.
killed 2 unarmed men and severely wounded a third person with an AR-15 that did
Apologies.
not belong to him. This isn't a situation where he was protecting his home or his family. He killed people after traveling here from Antioch, Illinois,
This
and staying out after a citywide curfew.
Yeah, good, object.
Curfew charge anymore. There's no.
Apologies. He's a snake, Spike. You've got no sound? Have you got, okay, have you got no sound? Okay, 1 second. Why have you got no sound?
The things
Have you got
that I
audio
just
now?
told you are in doubt in this case.
Have you got audio?
So when we think about the defendant, I'd like you to consider, as you think about this case, what his true motivations were. Was this a situation where he sincerely cared about car
Thank
source,
you.
even though he'd never heard of it, never bought anything there, never worked there, and not even its owners
Apologies, this
were
is a
out there
bit
that night protecting?
tricky.
Was he genuinely interested in helping people? He ran around with an AR-15 all night and lied about being an EMT. Does that suggest to you that he genuinely is there to help?
every time he says AR-15.
He's not there for the same purpose as the protesters. So why was he there that night? When you think about these things, I think there are some things that we can all agree on. In America, it's hard these days. People are polarized and there's a lot of political issues back and forth. And the judge has made it clear this case is not about politics. There is common ground here. We have all agreed, and I asked you this 2 weeks ago today. Raise your hand if you agree life is more important than property. And all of you raised your hand. We also agree that no one person's life is more valuable than another. You don't get to kill someone simply because they're a drug dealer. You don't weigh a pastor's life over a teacher's life. You don't weigh a police officer's life over an engineer's life.
Actually, in American law, you do get to kill people for breaking
I think we can also agree that we shouldn't have 17-year-olds running around our streets with AR-15s, because this is exactly what happens.
Oh, it's
And
happening all
finally,
the
I
time.
want you to keep in mind that we've all read stories and heard about heroes that step in to stop an active shooter or to give their life to save others.
No, the heroes are the
Many people in
shooters.
Wisconsin went out and got carrying concealed weapon permits just so that they could be there in case there was an active shooter and wanting to stop them. So when you consider this case, look for the truth. So many people look at this case and they see what they want to see. They have a preconceived notion and they tailor the facts to fit whatever they believe. You all agreed to keep an open mind. You all told us you didn't have any of those preconceived notions. Now you've heard the evidence, and it's time to search for the truth. So consider, for example,
Look at
whether
number
or not it's
4.
heroic or honorable to provoke and shoot unarmed people. Consider whether it makes someone a hero when they lie about being an EMT. I think all of us are familiar with someone who does the sorts of things that the defendant has done. They enjoy the thrill of going around and telling people what to do without the courage or the honor to back it up, and without the legal authority to do so. And when you think about the defendant's behavior in this case, contrast it with Anthony Huber, a man who was there because he knew Jacob Blake, who carried his skateboard everywhere, and who rushed towards danger to save other people's lives.
Wanker.
So when I talk to you here in my closing argument, I'm going to focus first on the murders that the defendant committed. Second, I'm going to address some background issues, give you some context, and talk about some of the things that I don't think are relevant to this case. And finally, I'm going to tie it all into the jury instructions that the judge just gave you. As prosecutors in this case, my colleague Jim Krause and I have tried to present you with all of the relevant evidence that we think you should consider in this case. And I told one of you in jury selection that at the end of this, you would be the expert. You would have all the information. You would be the one who would know all about this case and make that decision. And that's what we've tried to do. So let's go to August 25th, 2020. The defendant came from outside our community, carrying a gun that wasn't his, because he expected and anticipated violence that night. And he pretended to guard what turned out to be an empty building owned by people he'd never even met, while fraudulently claiming all night long to be an EMT. There were a lot of people out that night. Some people stayed home protecting their homes and their families. Others went to their businesses, boarded them up, and protected them. And a lot of those people had weapons. A lot of them had guns. There were other people who came along to protect Car Source or Ultimate Gas or other businesses. And many of them were armed with AR-15s, just like the defendant. In fact, you're going to see a video, and you've already seen it, of a clash between people with AR-15s at Ultimate Gas and other folks that are, I guess, protesters. And there's people getting in people's faces. There's yelling, there's shouting, there's even shoving. And yet, in this entire sequence of events, from the shooting of Jacob Blake on Sunday, August 23rd, 2020, all the way after that, everything this community went through, the only person who shot and killed anyone was the defendant. Yes, there was property damage. No one's here to defend that. No one's here to tell you it's okay to commit arson or looting. No one's here to tell you it's okay to be rioters. I'm not defending any of that. You know, because you've been told in the testimony, I'm prosecuting Joseph Ziminski for arson. That's not okay. But what you don't get to do is kill someone on the street for committing arson. So let's keep that in mind when we're talking about the people involved in this case. So let's begin with the provocation and the murder of Joseph Rosenbaum, because it's all captured on video. As the defendant and Mr. Rosenbaum arrive at the 63rd Street car service,
Thank you, Ian.
Mr. Rosenbaum is ahead of the defendant. And as you see in the FBI video, when Mr. Rosenbaum starts to run, the defendant starts to run as well at the same time, as if he's pursuing him. Mr. Rosenbaum could not have possibly have known the defendant is behind him. There's no indication in this record that
Hello,
he knew
Jimmy.
the defendant was there. It's not an ambush. It's not a situation where he goes there and lays in wait for the defendant. The defendant arrives at that location,
Both, Shane.
and you hear him yell,
Both.
friendly, 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 because he's aware of the fact that the people that he's about to confront are hostile to him. And I'm going to show you in a moment the video in which the first thing he does when he arrives at that location is drops the fire extinguisher that he's holding in his left hand so he can raise the gun with his right and left hands and point at me.
No, is that illegal?
This is when you hear someone, I think the testimony is Rosenbaum, it's not clear to me, but either way,
the
yell,
pedophile.
gun, gun, gun. And then Mr. Rosenbaum charges around to try and stop the defendant from pointing his gun or shooting anyone.
Like
So let's take a look
good
at some of that
pedophile
video.
would. Enhanced video. I know, it's disgusting, isn't it?
This is Exhibit 73, the full drone video.
This is quite hilarious, though,
As we
because you
pointed
can't
out to
see
you
anything.
before, and Jim will point out to you here in a second on the screen, when the defendant originally arrives at that scene, the first thing you see him do is drop the fire extinguisher and point his weapon at people. And then the chase occurs right after that. And you're going to see that entire sequence of
Hi,
events
Higolini.
on
Hello,
the full
Scots.
drone video.
This is quite funny because you see fuck all. It's just dots in the dark. Right, this is evidence. Look. Imagine being the jury. You'll be like,
The defendant turns as he's being pursued and points the gun at Mr. Rosenbaum. And then as he enters the area between the parked cars, he slows and turns, and before Mr. Rosenbaum can even come close, he fires at him, shooting and knocking him to the ground.
Did you get that? Yes, Steve, but alone.
Now I'm going to show you the slowed down and zoomed in video of the defendant when he first gets there. And
This
Mr.
one's
Krause is going to
even
help
better.
me by directing your attention on the larger screen here to exactly where you will see the defendant.
Last time I spoke to Copper Cab, he had a heart attack. Actually happened. Look at this evidence. Look at it. Oh yeah. All right. Okay.
I'm going to replay it a few times so you can see quite clearly that the defendant sets the fire extinguisher on the ground with his left hand and then brings his left hand over to the gun and raises it and points.
Where? You can play it as many times as you want, mate. No one can see shit. Serious question. One in the chat if you can see what he's talking about. I can't, but maybe people can. I mean, that's the 4th time he's played it. This will be the 5th time. One in the chat if you can see it. I can't. I'm not being biased. I just can't see what he's talking about.
Under Wisconsin law, you're not allowed to run around and point your gun at people. This is the provocation. This is what starts this incident. The defendant rushes in and immediately points the gun.
Hello, Viking woman.
And as you'll see in a little bit, Mr. Rosenbaum doesn't take kindly to people pointing guns.
Hello, Jimmy.
I don't think anyone does. That's not unusual. No one wants to have the gun pointed at them, and no one wants to watch anyone else do this to someone else. We have the gun. It is in evidence as exhibit number 28.
AR-15, maybe?
I'm having the detectives check it to make sure that it is safe.
This pussy thinks people are scared of
The
that
defendant
gun.
comes running in and drops the fire extinguisher on the ground like this.
Didn't drop it, he put it down. Look at the press, look at the press,
This is
look.
what we see in the video. Him
We-
putting the fire
we didn't.
extinguisher on the ground and then raising the gun.
Your Honor, I'm going to check. He's facing the wrong direction.
That's an argument.
To actually have, I'll leave it alone.
No,
So
don't
what you
leave
see
it
in
alone.
that video is his left arm reaching for the gun, holding it up. You can see it again on the video here. His left arm reaching up towards the gun.
Oh, again, this.
That is what provokes this
That's not
entire
me.
incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create. That's critical right here. If you're the one who is threatening others, you lose the right to claim self-defense.
Yes, Billy.
Then we have the chase that occurs after that. And we have taken that drone video and we have slowed down portions of that chase for you. So what we have right here on the screen, this is Exhibit 84, and this is the middle portion of that incident.
This
And
one's
you can
even
see
better.
Mr. Rosenbaum chasing after the defendant, throwing that plastic bag, and then the defendant turns and points the gun back at Mr. Rosenbaum. And this is the moment in time when Mr. Rosenbaum essentially does sort of a little hop with both of his hands in the air. And the defendant has testified. He saw at that moment that there was nothing in the defendant's hand, or in Mr. Rosenbaum's hands. He was unarmed.
The man who threatened to kill him, right?
There's the defendant turning and pointing the gun. Mr. Rosenbaum leaps, his hands out to the air, and then watch here at the end. This is where the shooting occurs. Mr. Rosenbaum is not even within arm's reach.
Fuck off! He was after him. He'd already threatened to kill
I'll play
him.
that again.
Look.
The defendant is pointing the gun at Mr. Rosenbaum. Mr. Rosenbaum raises his arms off to the side. The defendant approaches these cars and slows down. And then turns and shoots Mr. Rosenbaum.
Self-defense. Rittenhouse gets the shit kicked out of him if he doesn't shoot then.
Finally, I'm going to play you Exhibit 86.
You're an horrible bastard, Dinger. I hope you... I just don't... I hope you are who you
This
are.
shows you the final part of that, zoomed in and slowed down. Here's the defendant running in between those parked cars, slowing down, and you can see just how close, or rather how far away, Mr. Rosenbaum was when the defendant shot him.
You fucked up, didn't you? How close? I mean, how far?
You can see from this video that Mr. Rosenbaum is not even within arm's reach of the defendant when the first shot goes off.
So?
The defendant fires 4 shots in quick succession.
Right. Do you know
And
anything
I'll come
about
back
guns?
to this in a moment, but you'll note during this entire sequence, it's the defendant who chooses where to go. He's the one who decides to run where he runs.
What, away from the bloke who
And
said
he
he wanted
slows
to kill
down
him?
right as he gets to these parked cars. That's what allows Rosenbaum to get closer. We've seen this on the aerial footage from the FBI, and I want you to see that perspective as well.
This one's brilliant. There's fuck all to see on this. What, are you meant to let the bloke who's chasing you grab hold of you before you stop him?
This is
from
Exhibit
hurting
25.
you?
This is the annotated aerial footage. You see the defendant approach, running
Look
in
at
the same
this.
direction as Mr. Rosenbaum.
Look at that.
This is where the pointing occurs in the direction of the Zeminskis. You can see Joshua Zeminski's right there on the screen.
Oh yeah, I can see.
I'm going to put the cursor over where the Zeminskis are. They're right in there.
Right. Is this Ants Canada I'm watching now? What's that
The
paedophile
defendant is
one?
pointing his gun right here, and he's pointing it in the direction of the Zeminskis.
Look at that.
Because they're standing next to that car.
Oh, clearly pointing it.
And then the chase occurs. Now,
Why-
what's interesting to me is watch when the
Why-
crowd starts to run.
Why is he chasing him though? You haven't mentioned anything
The
about
crowd's
that.
already starting to run here, even before the defendant has fired a shot. That's likely because they heard the first shot from Joshua Zeminski, and the crowd starts to run away. The defendant has testified that that shot from Mr. Zeminski had nothing to do with his decision to kill Joseph Rosenbaum. And I'll come back to that in a second. Finally, I'm going to show you this incident from the perspective of Drew Hernandez, because he is behind all of this. And then he comes upon Mr. Rosenbaum's body.
That's a good point, Skin Scar.
Is that audio playing? Why is the audio not playing?
How could you defend these people?
Why you're not hearing any audio?
flying around.
He's flying around.
At any rate, for this purpose,
I mean, people, don't get too annoyed by this. He's obviously going to use this to tell lies. That's what he's there for. Yes, Henry.
at this point, the defendant
Has shot and killed Joseph Rosenbaum, and Mr. Rosenbaum is laying face down. That's where he falls. Richie McGinnis actually rolls him over after trying to stem the bleeding here. You can see in the foreground that plastic bag that Mr. Rosenbaum threw on the ground. I don't think there's any dispute. There was nothing harmful in that bag. It was a clear bag containing some clear items.
Oh, he just threw a bag at him.
Dispute in your argument.
Fuck you. Thank you, Ian.
It's argument, and you'll be allowed to respond.
Yeah.
You can see in this video the crowd is attempting to save Mr. Rosenbaum's life.
Shot a paedophile. Oh no. Thank you, Ian. Yes, they do. They go next. But then the prosecution, I think, get another
We
go.
have
I
shown
think.
you the defendant murdering Joseph Rosenbaum from 3 different angles. The drone footage, Drew Hernandez, and also the FBI video. The defendant admitted that during this entire incident, he knew that Joseph Rosenbaum was unarmed. I'm going to come back to this in a little while, but there's this alleged threat that Mr. Rosenbaum made earlier in the evening to kill the defendant. I will debunk that. That did not happen.
LOL, pal.
One fact in this case the defendant wants you to believe that there's no video of.
Driving
In
home
fact,
today,
I have
our
video of the
pizzle.
entire incident. I've played
Look
it
after
for
yourself,
you. I'll show
mate.
it to you again. There's no threat.
Thank you,
There's
Jess,
also
for
no
that.
evidence that Mr. Rosenbaum, he never said, I'm going to take your gun. He never said, I want your gun. There's no indication of that. Dr. Kelly has testified that the first shot that the defendant fired at Joseph Rosenbaum hit the victim in the right pelvis, fracturing it. Mr.
Thank you,
Rosenbaum was
Jess. Thank you, Duck Boy
at that
Jiden.
point.
Much appreciated.
Whatever threat he might have posed, it's over. There is no further threat. He is falling to the ground, and the defendant doesn't stop after that first shot. He tracks Mr. Rosenbaum's body all the way down, firing 3 more shots. A second shot, which goes through Mr. Rosenbaum's, and then a third and fourth shot, one that grazes the right scalp and one that goes right into Mr. Rosenbaum's back.
Yeah, because
And
one
that
isn't
is the
enough. Well,
That
that's
is the
why he
one.
needed 3.
That took Mr. Rosenbaum's life.
Shame.
There is no evidence that Mr. Rosenbaum was reaching for the defendant's gun. And after that first shot, there's no way Mr. Rosenbaum could have taken that gun even if he wanted to. He is already falling to the ground. He is helpless. He is vulnerable. And as I said, the kill shot is the one to the back.
Kill shot.
This is that wound. Dr. Kelly testified that the angle of this shot was from the left shoulder towards
Agreed.
the center of the back, and the bullet continued on down towards the right lower back area, tearing through bodily organs and killing Mr. Rosenbaum.
But this man has broken the law, Albert. He's done
Here's a
things
picture of the wound.
he
to
knows
the
he's not
hand.
meant to do.
There's been a lot of testimony about this wound. This
But
is
I
one in
agree.
which the evidence suggests that Mr. Rosenbaum's hand was most likely turned in this position, palms outward with his thumb to the ground. When the wound, the bullet goes through the area in between his middle finger and his ring finger and penetrates the lower knuckle of the middle finger and the index finger before exiting. Dr. Kelly testified there's soot in that area, suggesting that the hand was close to the end of the defendant's barrel of the AR-15 at the time of that shot.
Trying to grab it.
The defense wants you to believe it's there because Mr. Rosenbaum is deliberately reaching for the gun. Well, that doesn't make any sense. First of all, Mr. Rosenbaum has been shot in the hip. And
That's why he was grabbing
over.
for it.
He is falling, not even able to control much of his movements at this point.
Probably.
When you're reaching for that gun, this is not the way you're going to do it. This is not going to be effective. I submit to you, ladies and gentlemen, to the extent Mr. Rosenbaum's hand ever got close to the end of the defendant's gun, it was completely inadvertent, not at all intentional.
Thank you, Packer. Thank you, Jess. And thank you, Duckboy Jardin, for those entropys.
Now, we've heard a lot about the Zeminskis in this case, and I just want to carve them out of this case right now because it's a red herring. It has nothing to do with any of it.
I think the defense will call all this, he didn't mention why he was being chased.
They could work this into their self-defense claim and
Cheers,
make
Becca.
an argument that that first shot by Joshua Zeminski somehow made the defendant fear for his life. Unfortunately, the defendant wasn't on board with that because in his testimony, he told you that that shot had nothing to do with his thought process. It didn't affect him in any way. He said he didn't think the shot came from Joseph Rosenbaum. He knew Joseph Rosenbaum was unarmed, and he admitted to me, you can't kill Joseph Rosenbaum for something Joshua Zeminski did.
Look
So
at
let's
the
just
collar
call
of that
Joshua Zeminski
suit.
out of this
Look
case.
at the collar.
I'll deal with him on his arson trial in January. But until then, it doesn't factor into any of the decisions the defendant made. And in fact, as you see on the FBI video, the Zeminskis continue walking straight on down the sidewalk. They don't pursue the defendant. They don't threaten the defendant in any way.
Cheers, Matt. I like a karma grift. Thank you, mate.
Now, the defense wants you to think Joseph Rosenbaum was there to attack the defendant. We'll never know what Joseph Rosenbaum was thinking because the defendant killed him. So we're just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm.
Effortlessly dislikable, this prosecutor.
This is a fist fight. This is a fight that maybe many of you have been involved in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, we're whatever. But what you don't do is you don't bring a gun to a fist fight.
No, that's...
What the defendant wants you to believe is that because he's the one who brought the gun, he gets to kill. So I want you to contrast this. Two different scenarios. One scenario where there's two guys who are throwing punches at one another like a bar fight. I think we'd all agree you can't kill someone. You can't punch the guy, knock him to the ground, and then get on him and strangle the life out of him. That's murder. So what's the difference here?
Not necessarily. If he comes into your house...
The only difference is the defendant brought a gun.
Yeah, but
He
so
brought
did
his
someone else.
AR-15. That's why.
But one of your witnesses who got shot in the bicep brought a gun. You're going to mention that?
Was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told you that he thought Joseph Rosenbaum was going to take that gun and not only kill him, but kill other people, which is really ironic considering the defendant is the one who killed people in this case and the only one.
Can anyone confirm if the defense get the last word? I've got a terrible feeling that the defense get the next thing, but then the prosecution get another one, but I'm not sure. Anyone know for sure? That would be good information.
Against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people. The defendant fired 4 shots at Joseph Rosenbaum and caused 5 wounds total. The first shot fractured Joseph Rosenbaum's pelvis. This causes him to be helpless. He is falling face first to the ground and he is vulnerable. The second shot went through his left hand, probably ricocheted off the ground and hit his lower left thigh. It's a flesh wound. I'm sure it hurt, but probably not all that serious. The third and fourth shots are as Mr. Rosenbaum has fallen almost completely to the ground. He's parallel to the ground. He is almost face first to the ground. The defendant fires a round into his upper back, which is the kill shot, and another round which grazes his right scalp.
Hello, Rollo.
At this point, As you saw in that video, a crowd rushes to that body to try and save Joseph Rosenbaum. They're trying to put clothing on the wound to stop the bleeding. They're going to take him across the street to a hospital. KMH, Freighter South, is literally right across the street. And this crowd, except for the defendant, are all focused on trying to save this person's life. A person, by the way, they probably had never even met before. Because that's what most people do. Richie McGinnis testified. I rode with Rosenbaum in the back of that SUV. I told him we'd have a beer together when this was all done. Mr. Rosenbaum was unable to respond.
And 12 Angry Men is
The defendant
also a good one,
decided to pull the trigger on his AR-15 4 times.
but not so specific.
That was his decision. And he is responsible for every bullet that comes out of that gun. He doesn't get a pass by pulling the trigger fast. He could have chosen to stop after the first shot,
That
after the
doesn't
second shot,
didn't stop the
after the
bloke.
third shot, and assessed whether or not there was still a need to keep firing. But he went 4 times in 0.76 seconds. The defense has made a big point of this, how fast he fired.
Yeah.
As if that somehow excuses him.
No, because he knows how bullets
Exactly
and guns
the opposite,
work.
ladies and gentlemen.
Fool.
He controls how quickly he pulls the trigger. He is in control of that decision-making process.
And he knows
No one
how to
else made him
stop.
do that.
He knows how to stop someone with
And this
those
is indicative of
rounds.
someone who doesn't care about the consequences, doesn't care to stop and figure out, am I good? Do I need to stop? Or I'm just going to keep on going.
Well, I've
And as
seen
I said,
one.
he tracks the body all the way to the ground with those second, third, and fourth shots. The only way that you
Good
could
call.
possibly justify the murder of Joseph Rosenbaum is if you believe that Joseph Rosenbaum was actually reaching for the defendant's gun,
Okay, Liam.
and that a reasonable person in the defendant's position with that AR-15 strapped tightly to his chest,
Queensbury rules, Sigolini.
that Joseph Rosenbaum was even capable of taking that gun away as he's falling to the ground with a fractured right pelvis. And then, not only all that, you'd also have to believe
Okay,
that
thank you,
Joseph
people.
Rosenbaum was going to turn that gun around and use it to kill the defendant. You have to believe all of those things
No, you don't.
to justify the murder of Joseph Rosenbaum.
No, you don't.
That's why the defense is trying so desperately hard to convince you that Joseph Rosenbaum threatened to kill the defendant, which never happened.
He did.
That's why they're trying so desperately hard to convince you that Joseph Rosenbaum was reaching for that gun.
Oh, see,
Because
Lee's
if
saying
he's
what
not
I
reaching for
said.
that gun, and he's not going to use it to kill the defendant, it is not justified. There is no valid self-defense claim.
It's really lucky that Bing is so
One of the things the
dislikable.
judge has instructed you is that when the defendant provokes the situation, he has to exhaust all reasonable means to avoid killing someone. Did he? He didn't have to shoot. He's the
Can anyone confirm whether the prosecution get another pop after the defence? Because I don't know, and I'm getting mixed messages, and it would appear to be very important at the moment. Can someone maybe Google it?
doing stuff to cars, and the defendant had no escape route. The crowd's actually already running away at this point. They've heard the first gunshot from Joshua Zeminski, and they're already starting to scatter. But if you look on the video, there's a huge open space in that lot where the defendant could have circled back around, and he actually does circle back around after killing Rosenbaum, where he could have gotten away.
No,
He has to exhaust
I'd say
all
no.
reasonable means of escape before killing Mr. Rosenbaum. Your Honor, I do have.
I know the defence can rebut, but do the prosecution get another pop after the defence is rebut?
Okay, thank you.
Please don't talk about the cases during the break. Read, watch, or listen to any account.
Right, okay.
We will begin again at 1:45 too soon. Oh, well, I thought we'd have a leisure. No. How about
Oh, hilarious.
1:45? Is that a better idea? Let's do that. Please don't talk about the case.
Okay, so we really need this cleared up because I haven't got a clue. I've got a feeling that the judge said that the prosecution get the final pot after the defense have done their rebuttal. But what an unpleasant piece of shit Binger is, really. Just a horrible, horrible person. I mean, look, I agree with what Albert said. You know, that if it's going to be a fair trial, you have to have a prosecutor for the state and you have to have defense. You know, 2 people were shot dead and 1 bloke had his arm taken out. Now, if the politics were slightly different, most of the people here would be, you know, saying that the prosecution needs to do a good job and we'd be hassling the defense. But Binger has been a snake. Binger has done things he knows he's not allowed to do. Why they didn't get a mistrial with prejudice, I don't know. When he twice stepped over Rittenhouse's Fifth Amendment rights, I don't know. But you know what a fairy story he told there. I mean, the bloke was clearly never had a fight or anything. I'll tell you now, if I had a gun with, let's say, 9 bullets in the chamber and they were little bullets and some bloke was chasing me in that sort of situation, the heated situation of a riot where he clearly hated me because he knew I was politically opposed to him, I'd empty the fucking magazine into him because you have to. Like Moslab said, that shot in the pelvis, he probably wouldn't have even known that had happened. People in war situations don't know they've been shot until someone else sees all the claret and they go, oh, and then they look down and they realise they've been shot. You know, you can't just shoot him in the hand and think he'll go, oh, all right, then I'm not gonna carry on pounding your head into the ground. No, you go, just, I don't want you to hurt me. It's called self-defense. Doesn't matter whether it's 3 bullets, 4 bullets, 5 bullets, 1 or 2. You know, 1 bullet in Binger's own testimony. 1 bullet didn't stop him. 2 bullets didn't stop him. He's trying to make out the bloke fell onto him. No, the trajectory of the bullets don't support that argument at all. I just hope the defence pull this out of the bag now because this could be awful. Absolutely, Spike. Absolutely same as that. I was years and years ago, back in the dark days, I was hiding under some rubbish bins, you know, black bags. I don't know if it's the same in America. This was before the old wheelie bins. And it was fucking disgusting. And I managed to pop one of them and all this sort of juice was running all down my neck and I was nearly puking. But some bloke was coming to get me. And he was way down at the bottom of the block of flats. I was about 3 stories up. And there was a glass bottle of Tizer or something empty. And I smashed it so that I had a broken bottle in my hand. Not for fun. I done it because if that fella had got hold of me, because of why he was trying to get me, he would have probably killed me. If not killed me, battered me within an inch of my life. You know, and people do die when people attack them. You know, he could have thrown me over the balcony. He was a psychopath. And if he'd have got me, I'd have jabbed that many times as I had to. Even when he's not doing it. I am not, you know, imagine someone comes in your house and you've got your kids upstairs. And you're just going to go, right, I'll just fire 1 bullet and see if that stops him. You can't risk that. Because 1 bullet, if it doesn't stop him, it's too late to fire the second one because he's now on top of you and the barrel's sticking up in the air. So you just let it go. His own evidence showed that 3 bullets in like 3/4 of a second. Rittenhouse just thought, no, I'm not going to let him get hold of me. Gag. It's just ridiculous. Absolutely ridiculous. I'll just pop these on the screen quickly because they didn't get a fair amount of time earlier, and I do appreciate all donations. We've been going for nearly 3 hours now. Lee James said it's like a really shit comedy show. Thank you, Lee. And Duckboy Jiden said he should be on trial, not Rittenhouse. Thank you, Duckboy Jordan. Jess said, I'm not sure if he'll hear this, but a shout out to our Pizzle. He's driving home today. If you're listening, our pal, I hope you're all right, mate. And that would be super cool if you were tuning in. It's a shame you're not here with us. So thank you for those entropy donations. Yeah, we're nearly at the 3 hour mark. It's the Rittenhouse Megastream. I'm shattered. I won't, because I knew I was going to do this later. I put in 3 hours of my day job before the I'm not being a martyr here. I'm just filling in time basically. I put in 3 hours work before the morning stream. Done 2.5 hours stream. Then had to make a video for work and do a load of other stuff, and that's why I was 10 minutes late. It was that fine. But Rag sent me a message saying that stream's about to start, and I was like, yeah, I'm just finishing work. I'm just making the thumbnail for the Rittenhouse thing. It was that fine. But we got there in the end. And it's lovely that we've had 200 people here. Really nice. And it's nice because we can get your comments on the screen and not, you're not lost in a melee of. You're not lost in a riot. Thank you, Skin Sky. That's very kind of you. Very kind. You're a regular and very generous supporter of this channel. It's much appreciated. I hope you're enjoying it, people. I mean, it's tense, though, isn't it? It is tense. When you hear the prosecution get to have his say like that, it sounds awful. I still don't know what's happening. I still don't know who gets the last word. I hope to fuck it's the defense, but I'm not sure. I think I heard the judge say that it's prosecution, defense, prosecution. I don't know. Maybe just a bit of pessimism crept in and I managed to filter that out. Okay, foot golf. Thank you, Skin Scar, again. I've cleared it up. Prosecution, defense, prosecution. Goes to jury. Judge said that, not me. There you go. That's what I said. So those seeking to prove have the last word. Yeah, I was worried it would be that. That isn't great, is it? That really doesn't help the defense. Prosecution, defense, prosecution. Because that just technically that isn't good. Prosecution gets to say their bit, you get to pull that apart, but then they get to pull you apart. And you're left with bingers ringers. You're left with bingers ringing in your ear. Nice one, Foot Golf, appreciated. Foot Golf, did you see the stream this morning? I put Decker Hedgie on the screen. Did you see the state of him after that fight? That geezer nearly jabbed his head in half. Cheryl Peters says that Google says prosecution gets the last word. Yeah, but I don't think it's ever as simple as that, depending on what type of case it is. And Foot Golf there said that the judge said it. So, Foot Golf, can you confirm, did you go back and hear what he said? Did you check it like that? Because I thought he said that. And there you go, Ian Mars saying as well, prosecution opens, defence speaks, and the prosecution gets a rebuttal chance. That isn't good. However, like people have already said, I think most of the jury have made up their mind already. Shane says, I've watched enough Law and Order to know. I'm going to put the fan back on, people. It might be 1 a.m. here, but it's still 28 degrees. And I didn't even get a chance to go out and get any Galan today. Your adrenaline is off the charts. Yeah, it's a bit much for me, all this. So I'm terrified that this kid is going away, not just because of him, but because of America, because of the Second Amendment. I mean, what's this going to do for police? What position is this going to put the old bill in? It's that, like that idiot on The View said. She said, "Oh, if Rittenhouse goes free, this is going to send a message out to people that you can do this and not go to prison." That should be the message that goes out. You can defend yourself with lethal force in America without going to prison. That's how it should be. Hang on a minute, what's going on here? Sorry, people, just give me 1 second. I've just got a bit confused. A little bit. Nice to have 200 people here, 190. If you like reading, I write true stories from my life. Link in the description. It's called SUBSTACK, totally free. There's 12 stories in the archive. Oh, and they're very good. They're very, very good. If you like that sort of thing. If you don't like it, they're probably crap. If you don't like them, you won't like them. But you're going to have to read them to find out if you like them. So, you know. What is going on? There's something not right. Let me just refresh my entropy. Refresher. If you're listening, Pizzle, hope you're all right, son. I'll get to that super chat in a minute, Rags. I'm just updating my entropy because my computer's on its last leg, so I have to do it every few minutes. I've been doing it. No, it still hasn't updated. Skin scars. So where are we standing at the moment, people? 1, he walks. 2, he goes away. 1, he walks. 2, he goes away. Let's see where we're standing at the moment. The chat is absolutely firing at the moment. Did I read that one out, Matt? Carl Karma? Or Kamala's addressing out. I hope I did. Thank you, Matt. I think I did. It rings a bell. Good to see Scott's Armour in here. Nice to see you, mate. Hello, Pete Butterworth. He was thinking about the kids. There you go. Jack, that was a great comment. Did you see the back of it all just stuck up? If I had a suit like that, I'd go to my tailor and I'd make his skin stick up like that. 1, that he walks. 2, that he goes away. What are we thinking now? What's your latest thoughts? And, you know, not that it means anything, but I'll be interested to see whether maybe there's been a change in optimism or a change in hope between earlier and now. I mean, wouldn't it be mad if they lock him up and then they get out of their jury service and they find out that it was a pedo and a burglar and a murderer, and they'd be like, oh. I mean, not, and you know, that unfortunately, but also fortunately, that doesn't count. And you know, I've had situations, so friends of mine where previous hasn't come into it, and it's been fucking lucky. But there's a particular previous there, if you know what I mean. Nice 1 foot golf. Human nature says the jury's mind's already made up. Yeah, I'm tending to think that. Oh, okay, so that's interesting. The prosecutor's second go They can only rebut what the defence said. They can't introduce. Okay, that's interesting. Although I wouldn't put it past Binger at this stage. You know, he's done it before. Cheryl Peters, you said prostitution the first time. That's what she said. Any UFO clips? I could probably find some metalworking. Ian Marr, a contribution to the marathon effort for the last few days streaming. Great content and the community is muchos apreciados. For mi diablo. Well, I thank you, Mr. Marr. It's a real pleasure. It's a pleasure to have such a nice community. I really do enjoy streaming. You know, I have to drag myself away from it really because I've got a job and I need to work. I need to keep the business running, especially in these fucking supply chain issues. What else we got here? Main chats between each other. Rag says, give us a kiss, you big tart. You regretting that, Rag? I'll send you one. Thank you, Rags. That's my Substack, people. Rags, thanks for that donation, mate. Moderator donation, eh? Fucking hell. Moslab says, unlike the women on The View, we don't have the Medusa defense. Sometimes we need weapons. Yeah, exactly. I mean, I can't say too much, but if I'll say enough so you know what I mean. Cambodia's pretty much lawless, thankfully. That's all you need to know, really. And it makes me feel a hell of a lot better. Not that Cambodia is dangerous, but if we get a pad out in the provinces, you know, they know I'm a barang. They know I'm a target who's potentially got something as simple as a laptop, which is, you know, worth money to people who haven't got a lot. Hello, Horace. How are you? Good to see you. Thanks for the old your favourite writer. You sent me a link to another one of his fantastic pieces. I'm still trying to work out how you unconsciously fall into or under the surface of the scum or whatever. I just still can't work out how you unconsciously do something physically. I don't know. It just makes no sense. A lot of ones in the chat. I mean, I tend to think that I've always had this thing, and even though, you know, I'm gonna preface this by saying I'm not superstitious, and then I'm gonna give you one of my superstitions. So I am superstitious, but I don't want to be. But it's the old tempting fate, and it feels like if you're hopeful, there might be some kind of collective consciousness that will help the universe conspire into our favour. Do you know what I mean? I suppose it's just a sort of a more contrived and adult version of, if I don't tread on the cracks in the pavement, I'll have a good day at school or whatever. Jack still has faith that justice will be served. Coolio says never trust a jury. I mean, it's weird, isn't it? 12 of you lot I'd trust, but when you see Mark Dice walking up and down the beach asking people stupid questions and they don't know, they know fuck all, you sort of think, well, imagine 12 of them on the jury. The geezer's going away. I think I will say this much. I think the judge thinks it's self-defense, all of them. And I think that if the jury convict him of Murder One or any of those other ridiculous variations that just became it was like some avant-garde German poem. I think he'll give him the lowest possible sentence. I think the judge will try and do what he can, when he can, if he has to. Yeah, I agree, Spike, but nothing would surprise me about America at the moment. Nothing. Because I've already had my mind blown out of what the Biden administration is doing to that incredible civilization. It's just mind blowing. Now, I don't know about this. Can a judge overrule a jury's verdict? I'm not saying that's what you're saying, Duck Boy. Maybe I've taken that out of context. You'd certainly hope so. Yeah, there's always an appeal. The issue, I guess, and I am guessing, I'm no legal expert, British or American, or any country for that matter. I'll tell a lie, I probably know a bit about Cambodian law. How much money you got? The problem with the hung jury, I think, is that there's many counts. So there might be a hung jury on this count and this count, but they might find him guilty on this count. So the jury can be hung as much as it wants. I think I've got that right. But again, I'm just chatting with you at the moment. It kind of feels like that. Yeah, they will. This is interesting from Kieran. Hello, Kieran, mate. Chauvin was never going to get off because they used some bullshit technicality charge rather than a murder charge. Yeah, that's what I read about that. Kyle's up for murder, of which he is innocent. Now, it's weird. Is he up for murder or is he up for self-defense? It's a weird one, isn't it? I mean, he's up for murder, but if you can... The defense hasn't got to prove self-defense, have they? The prosecution has got to prove murder. It's fucking complicated stuff, law, isn't it? I have to say, though, in my time, I've had some wicked solicitors. Skinscar says, British courts now bring up all your former non-convictions. Fucking hell. The chat is moving too fast. Can you slow it down? I think so. Let me see if I can do that. I'm just trying to do it without doxing my StreamYard people. 1 second. Bosh. Close that. I think I can put it on slow mode. Is it really going that fast for 200 people? It's amazing how much people are chipping in. It makes it for, this is like the perfect number really, because there's enough people in here for different opinions, but you also get to have your say. Let me see if I can put that on slow mode. Never done this before, good lord. How do you do it? Create a poll? No, I want to be on slow mode. Toggle timestamps, pop out chat, participants, manage moderators. Does anyone know how you put the chat on slow mode. Custom emojis. Give myself a super chat. Tried that before. Said I couldn't. Create a poll. Hide chat. No. Come on, there must be one more option. It's slow mode. Does anyone know? I'm trying, extremely grumpy old bastard. How do you do it? Maybe I have to actually go into my... Maybe Beef Base said the speed's fine. Let me see, hang on. Let me have a look. How put YouTube chat slow mode? Create a live stream. After entering the title and description, click create stream. Click settings. Click live chat. That's not the same thing, right? Let me see if I can go into the back door of my settings. YouTube Studio. If the whole thing suddenly breaks down, Cheryl Peters, I've got that super chat. I won't miss it. I'm just going to see if I can slow the chat. But my computer, that's asking a lot of the old computer, to be honest with you. Amazing how this is totally, hello Horace. Amazing how this has really grabbed the hearts of patriots, though, isn't it? Well, I don't want to say too much about it, but I've said enough. I think you know what I'm getting at. Fucking nice selection as well. Cheap as chips. Well, apparently I've heard that that Liverpool Women's Hospital bomb didn't go off. What you saw was the detonator. I mean, again, I'm no expert, but that's what I read. That the that's how comes the taxi driver got out of the cab, because that wasn't the explosion. It was an explosion, but it didn't set off the. Someone told me how to make C4 the other day. Really? Oh, if you know, I wouldn't put it in the chat. It will not go down well in the future. But yeah, someone told me how to do that. Right, I'm going to see if I can put this stream into slow mode. Let's see if there's something in here. Customization. Subtitles in the screen. Playlist, audience. Show more. Paid promotion. Do you want to buy a lump of sexy plastic? Comments and ratings. That's not the same, is it? Let's try settings. Community. No. General. No. Channel. Advanced settings. No. Permissions. For fuck's sake. Hello, Rags. Rags, before you say anything, there's a good chance that everyone can hear you. Pardon? Oh, okay. Oh, okay. I'll forget about it then. Nice. I think I've just found out how you do it. I think you just type command slow on in the chat or something. But nice one, mate. No problem. I'll forget about it. Cheers. Cheers. Ta-da. Well, apparently I don't have to do it anymore. It's calmed down a little bit. So there you go. Good Lord, I've nearly drunk. What's that? 3 litres of water. And I am on and off the pisser all the time. How's your birthday been, Lumi? Did you have your oysters and champagne? No, I got that. I got the story. But it was ridiculous. Yeah, that was when it was all going really well and everyone thought, yeah, this is going to be a walk in the park. And then as the week progressed, it didn't go so well. That's the way to be, Rags. Oh, this is interesting. So foot golf, this is the bloke in the taxi wanted to go to a cathedral where there was a service going on, and what, the cabbie just drove to the hospital, probably in case he got blown up. But I think the actual bomb didn't go off. Yeah, that I think that was ridiculous. I think that, you know, they know that Mr. Brad, the prosecution know that worked in the defence's favour, worked in Rittenhouse's favour. The fact that 3 bullets went off, I don't think it was even 1.5 seconds. I think it was less than that, but don't quote me on that. But because 1.5 seconds is quite a long time, isn't it? It's like, but that's it. It's quite a long time. But so because they knew that was strong for the defence, that he just sort of went, gang. They then had to sort of go, the defence said that was a good thing. And so they had to attack it because it is a good thing. If it was like bang, couple of seconds, bang, couple of seconds, bang, then Rittenhouse would be fucked. But it wasn't. It was what you'd do in that situation. You'd get rid of the clear and present danger, which would mean firing 2 or 3 into him. And what it fucks me off that, you know, I don't know why they didn't get a better ballistics expert in to explain all this. You know, I remember the first time I fired a 9mm, and I was talking to the bloke about it, and he said that you often have to empty them into someone to stop them. Someone running at you, they'll run through 3 or 4 of those. I mean, people who Moslab and others might be able to confirm or question that, but you know, there's a reason there's a magazine on those guns, because one ain't going to do shit. Maybe a shotty or something. He can direct the jury to acquit before they make their decision, though. That's the thing. Lars says, this is the new America, so bad shit can be expected. Yeah, without a doubt. Aramas says the judge determines the sentence, the jury determines guilty or not guilty. Yeah, I think if they go guilty, it'll be the smallest possible sentence, because come on, this is clear as day, and it will just set such a terrible precedent for American law. I mean, just look what it's going to do for the police. There'll be no more. The police won't be pulling their guns again, and the left will be like, ha ha ha. Until it's one of them getting raped. Hello, Stig. It really is. I've felt like it all night. Add to that my inability to work technology. Add to that my dying computer. This has been a nightmare. But we've still got 175 people in the Megastream. I don't think they have manslaughter in America. I think he gave them different levels of homicide. Again, I'll need someone to confirm that. Hello, Tito. How are you, mate? Not even Tito. That's how knackered I am. Tony. Well, it started with the same word. Thank you, Cheryl Peters. A lady for you while at recess. Remember to wash your hands before going back to class. I always wash my hands after a whittle. But I might have to do I might have to do the other one. Dennis says, just read faster. Oi, Dennis, read that. Thank you, Cheryl. Well, it's funny that I'm only on that now. And sorry for all the faffing around, but it's hard for me to read everything and choose what to put on the screen. USA does have manslaughter. Okay. Did I see Charlie? Hello, Charlie. You all right, mate? Strontium Dog's in here, is he? Oh, hello, Tito. Tito, did you manage to shift any calendars? If I could sort the post out, I would have grabbed one, mate. A very fine calendar. You're a very talented illustrator. Willow says 3 levels of homicide: 1 dead, 2 very dead, and 3 stone cold dead. What's Grego saying that's making people laugh? Manslaughter is transphobic. There you go. Paxmax, first degree. Okay, so this is what we heard the judge say 1,000 times, and Paxmax was the only person who remembered it. First degree reckless intentional homicide. Hashtag no homo. First degree intentional homicide. Hashtag no homo. First degree attempted intentional homicide. Hashtag no homo. And possession of a dangerous weapon. Well, I've certainly got the last, if you know what I mean, Paxmax. Non-slaughter. Well, that's why I asked Tito, because someone wrote to me for your email and said, I'm trying to buy one of Tito's calendars and I'm getting fucked about by Etsy. So you sold 2 and then you got yeeted. Probably because they were pictures of sexy women. Maybe do a calendar of absolute munters with blue hair and national health glasses, and they'll probably put you on the front page. Come on, Tito. This is the liberal West, mate. You can't have sexy women. You should know that by now. They're banned from the London Underground. All right, I'm going to top up my water. See you later, 42. People, do we know when they're going to start again? Because I might have to go and have a number 12. No, actually, a number 2. Well, it's on anyway, so it'll start again. I'll just make the screen bigger. I'll take the telephone and the vape. Might be sometime. 12 minutes. I've got 12 minutes to have a plot. Okay. Nice one, Eldritch. Right. Well, I'll make it bigger. And I'll see you in a moment. No listening for the dropping kids off at the pool. really should have used that time to put some charge on the headphones. I'm going to do that now. Which will probably do something wrong. Let me know if you can still hear me. Oh, man. You'll be surprised at that. You'll be surprised how quickly you can make a crack pipe and rinse up some cocaine, I'll tell you that. It could be days. Can you still hear me? Andrew feels abandoned. Hello, my boy Tom. You off that roof yet? Your browser has lost connection to your screen share audio. That's all right. I'm charging my headphones, so you can still hear me. That's good. When it kicks back in, I'll have to put my headphones in. But they're quite. Listen, I am not sponsored by Apple, people, but these AirPods are life changing. You charge up the case, which then charges up the earpods, and you get about 8 hours of straight listening, right? But if you're out and about, you don't need to take the charger, you just take this. And if your AirPods run out of charge while you're out, you put them in here, I think it's 20 minutes and they're fully charged again. And the case will charge them, I think it's 3 or 4 times. Not bad, man. Really, really handy. And I'm sick of getting normal headphones with the wires in and breaking them because it's always like ping, you know. So Tito, is there any comebacks with Etsy? Can you like say to them, fuck off? Why have you banned my calendar? Because the annoying thing about it is, you know, people make that sort of wish to purchase after I shield your calendar. Etsy might sort that out a week later, and people just sort of forget, or they lose the enthusiasm. This is why. You know, when you go to a shop and you put a few things in your cart, and then you think, oh, actually, or you get interrupted, so you forget about it, or you know, anything can happen. But then you get an email. Oh, you left these items in your cart. You know, they want to remind you. And I'll tell you what, from someone who knows how this works, if you get an email saying you left these items in your cart, don't buy it then. Because if you give it another week or so, 50% of the time you'll get another email saying, if you want those items, here's a discount. So that's a bit of insider information for you. What has Jess done that everyone's proud of? Spike says, Dangerfield, Kyle will walk. He knew it was better to be judged by 12 than carried by 6. Yeah, Moslab said that. I hope he does. We're not going to find out tonight. John says, AirPods make you look like an insect. I don't think too much help in that respect. Billy says, wired earphones always fail on me. You lose one ear usually. The wired ones. So I just always end up pulling the wire out of them, you know. And sometimes if I go to bed, I like to have audio books. And so I wear headphones when I'm laying down, which is all right when I'm on my back. When you start moving and that, and they start going around your neck, it's not good. Tito, I'm waiting for their explanation email. They may send me. Yeah. So they just took it. Lee James, who said it's like a really shit comedy show, has sent another entropy saying, I do mean the court case, Chris. Yeah, you're all right, Lee. I was hoping you meant the court case. 1:45 in the morning here. I think I'll probably wrap this up after the defense because honestly, people, I've been working, and although this is a pleasure, it's concentration and it's not resting. And I've been working since about, when did I start? About 10:30 this morning. Fucking hell. 10, 11, 12, 1. 15-hour shift. Happy Monday. But as I always say, better to complain about work you've got than complain about work you haven't. And it's nice. It's a privilege to be able to have a stream. It's a privilege to have a job that I enjoy doing. You know. Jess has been assuming people's gender. People, what do you make of that Microsoft video I showed you earlier? That internal video. Hi, I'm John. I'm a Caucasian man in a blue t-shirt and some tight jeans. Hi, I'm Deborah. I'm Deborah. I'm in a nylon wig and some frightening makeup. Don't you dare say anything about biology, you bigot. You know, and they say it's for the blind people. Can you imagine all the blind people sitting there and someone goes, hello, I'm Rachel. Like, what the fuck's going on? Hello, Rupert. He says there's women outside Kyle's trial depicting Rosenbaum and the others as supermen. Absolutely effing nuts. Oh, that's very kind of you, Brandon's whistling butt plug. That's a sentence I never thought I'd say. Plenty of these too, thank you. And here's another sentence I didn't think I'd say. It's always nice to see a load of D's. I wish I'd have got a Galan today. I'm now obsessed with them. When I went there yesterday to get one, they only had one left. When the missus took me over there, they had about 50 of them. I mean, it's not that surprising. They're a shop that sells them. But I assumed at the end of the day, they'd probably have like 10, 20 left that they give to their family. But I got there and I went, any Galan? Any Galan? He went, yeah. And the one that was left, the bamboo tube, was squashed in the middle. And I think what had happened was when people pick them up, they give them a little feel. And someone probably picked it up and overdone the feel and give it a little dent. And then after that, other people picked it up and thought, why is that dented? Give it another dent. And no one bought it. So when Muggins here turns up, got any Galan? Yeah, just that one there with the dent in it. Oh. Thanks. The consumer experience was somewhat tested. Oh, you haven't seen it, LC350? Hang on, I'll see if I can grab hold of it now for you. I think we've got a couple of minutes. I'll keep an eye on the main screen just in case. It's so weird. It's an internal video that Microsoft made for staff basically, but it's actually mind-blowing. Now, how do I find it? I think it was Mark Dice I watched it on. Hang on a minute, this might be it. No, that isn't it. How peculiar. Oh, I've got it. Hang on a minute. Hang on. So for people who haven't seen this, what I'll do it like this so that we can still see. That didn't work. Now, what I'll do, I'll put the audio so it goes straight into the microphone, which is that. So, yeah, can I make it bigger without? Yeah, the court proceedings will.
I thought that people putting their preferred pronouns in their.
The court proceedings will start talking. We'll hear them, and I'll swap it all. But check this out. If you haven't seen this, this is an internal video for the staff at Microsoft. Check it out.
Twitter bio and email signatures was, well, a bit strange. Microsoft has taken things even further. And I'm sorry to have to keep saying this, but this video is real. It's not a parody making fun of wokeness. It is the wokeness.
Hello, everyone. I'm Kelly Gadilla. I'm a Caucasian woman with long blonde hair, and I go by she, her. I'm a product marketing lead here at Microsoft and co-host of the podcast Security Unlocked with this guy.
Yes, that would be me. Hello, everyone. I'm Nick Fillingham. I'm a Caucasian man with glasses and a beard. I go by he, him, and I'm a security evangelist here at Microsoft. We are so excited to be with you here today.
I mean, the madness, the absolute madness of this. Do these people really finish filming this kind of thing and walk off, set and think, yeah, that was mentally sufficient. Yeah, that was excellent. This is progress. This is the future we want. This is really sensible and isn't utter cuckery at all. Do they really think that? Surely they must go and have lunch and just go, fucking hell, that was a load of nonsense, wasn't it? It gets weird. Well, weirdly, Steve, that's the one thing he doesn't mention. And as Mark Dice says, what's the point of telling blind people what colour top you're wearing? They don't know what that is. They're blind. Partially sighted, perhaps. But if you're partially sighted, you'd hardly waste what sight you have got on a Microsoft internal video.
For Microsoft Ignite into focus, the theme of our show is security.
Of course, normal people are widely mocking the video, and our mockery is making headlines. And so Microsoft responded by updating their blog, explaining that they were doing it for the visually impaired who were tuning in. Why do blind people need another race, preferred pronoun, and hairstyle of the speakers, you're wondering? It's another one of those mysteries of the universe that'll never be solved. But they weren't just proud of their preferred pronouns and ashamed to be white. Microsoft presentations now feature a new moronic ritual, a land acknowledgement.
Hello and welcome to Microsoft Ignite. We've got a big day ahead and lots in store for you. First, we want to acknowledge that the land where the Microsoft campus is situated was traditionally occupied by the Sammamish, the Duwamish, the Snoqualmie, the Suquamish, the Muckleshoot, the Snohomish, the Tulalip, and other Coast Salish peoples since time immemorial. A people that are still here, continuing to honor and bring to light their ancient heritage. My name is Allison Wines. I'm a senior program manager in our developer tools division. I'm an Asian and white female with dark
Asian and white. That's a new one to me.
brown hair, wearing a red sleeveless top.
Of course, this wasn't an isolated incident of insanity. Last year at the Oscars, they did a land acknowledgement as well.
Tonight we have gathered on the ancestral lands of the Tongva, the Tatavian, and the Chumash.
Oh go Virtue, go Virtue.
We acknowledge them as the first peoples of this land on which our motion picture community lives and works.
No, it's not ancestral land. I mean, maybe it was, but it's ours now. It's called America. If we're going to have to continue belaboring the things that white people did in the ancient past, like stealing the Native Americans' land, then maybe we should start highlighting the shortcomings of every culture.
Yeah.
Like the Aztecs, who were Mexicans, who cut the beating hearts out of people on top of a giant pyramid, trying to appease Quetzalcoatl, the sun god, or whatever the hell his name was. It's not all fun and games, however. This cultural Marxism is spreading to other countries. Over in the UK, defense officials have been reportedly told when they introduce themselves to others to not only use their rank, but also their preferred pronoun. Columbia University in New York just released this new video to help educate people about this important subject.
Pronouns are used in place of a person's name. While many use she, her, and he, him pronouns, a growing number are using other pronouns like they, them, ze, them, ze, here, her, hers, and am. If you slip up and use the wrong pronoun.
I mean, in fairness, though, right? In fairness, and we were ripping the piss out of Z's 4 years ago. Have you? Give me a 1 in the chat if you've ever heard someone introduce themselves and say my pronouns are Z's. I mean, no one's going for that because they might have gone for it twice. But the first time when the reply was like, what did you say? Caesar? Okay. And then the second time it was, I haven't seen you since school yet. No worries. How are you? Well, I'm good. I go by the pronoun Caesar. What? Well, you don't call me him anymore. You don't say I saw him. If you're telling someone later about this meeting, you say you saw Z. How about cunt? Sorry? How about I say I saw that cunt? Why would you say that? Because you just told me to call you Z. And that is why I am going to call you cunt.
Pronouns?
Oh, cool. Would appear to be appearing, people. We are back. Let me get my cans on. And we will be back very shortly. Can someone let me know that you have audio in the on YouTube, please? Oh, whoa, this might be problematic. I don't think they're making any noise at the moment, in fairness. I think they're muted. But I will hear when they're not. I'm just going to try another video to see if I'm right and that I've got audio. Yeah, I've got audio, so they are muted. Thank you, Lee. Lee has given another donation there. He says, great stream, Chris. Hilarious. Nice one, Lee. Appreciated. No, they're not. They've just started. So can you hear it now? Can you hear it? Oh, no, I'm sick to the stomach with you, Binger. Can you hear it, people? We've got more Binger. You can't hear that? Okay, no worries. It'll take me 1 second. Apologies. It won't take a couple of seconds, yeah.
And as
Let
you
me
can tell,
let me
I'm
know,
trying to go in
please.
chronological order. I'm trying to go through these events in a way that makes the most sense. So count one of the information is with regard to
Cheers,
Joseph
Matt.
Rosenbaum. The second count of the information pertains to Richie McGinnis, who you heard testify. He testified that
Thank
he
you.
was in the line of fire.
Is the
behind
volume between
Joseph
me and them
Rosenbaum as the
okay?
defendant fires
Or am I
4
massive
rounds
loud
with
and
his
them
AR-15,
very quiet?
which is loaded
Let me know.
with full metal jacket ammunition.
Full metal
I'll talk a little bit
jacket.
more about that type of ammunition in a little bit. But you've heard testimony that it's the type of ammunition that is capable of going through body armor. It is capable of going through a squad car. It is designed to go through the target and continue flying on for up to 550 yards. Richard McGinnis testified that when those shots went off, he thought he had been hit. He thought his life
Okay,
was in danger.
I'll try and talk quietly.
One of the rules that I think most people who are familiar with firearms knows is always check your background, meaning know what's around your target and know what's behind your target. This is true when you're hunting, it's true when you're target shooting, and obviously it's true when you've got an AR-15 in downtown Kenosha in the middle of protests with houses and people nearby. But there's no indication the defendant cared one bit about his background. He cared one bit about where those bullets were going to go. And as I said, he put Richie McGinnis in danger. Richie McGinnis, after this incident you've seen on the videos, goes to try and help Joseph Rosenbaum and has his own video shows when he first gets there he finds Mr. Rosenbaum's body face down on the ground. And I'm going to play this exhibit 15 for you.
You okay? Just don't move, man. Don't move. All right, I'm gonna flip you over real quick. Oh, I'm gonna flip you over real quick, bro. Flip over real quick. Just gotta get pressure on this, dude. Where's it at? Turn around. Where's it at, dude? Get a light on it. Get a light. Give me a fucking light. Where? Where, dude? Where's the hole? Get the fucking light up.
This isn't evidence, is it? What is this? Pulling at heartstrings. That's not me. I wonder if they've done me. The court does do this from time to time. Probably works against the Aramas.
You want to talk about medics.
Just emotive.
You want to talk about people who care. You want to talk about people who were there trying to help. You just heard them and you just saw them. People who didn't know Joseph Rosenbaum. They just knew somebody needed help. And while that's going on, the defendant flees, callously disregarding the body of the man that he just shot and killed. And as he's running off, he's lying to the crowd about what just happened. This is exhibit number 12.
So there were just like 6 shots.
Went to hand himself into the police.
The defendant says he pulled a gun.
Maybe he thought he did.
That statement, he pulled a gun, was a lie.
Doesn't matter. The judge already said it doesn't
It's
matter
not
if he
true.
made a mistake.
The defendant knew it wasn't true. He's lying to the crowd as he's running away. Joseph Rosenbaum didn't have a gun. The defendant knew he didn't have a gun.
No, he had his cock in his hand.
The defendant is lying to save his own skin instead of going and trying to help the person that he has just shot and killed. In exhibit number 3, Gage Grosskreuz's Facebook Live video, he tells a similar lie. As they're running, Mr. Grosskreutz asks the defendant, "Did you just shoot someone?" And the defendant says something about the police and then says, "I did not shoot anyone." And this is similar to the lie that he told Jason Lukowski at exactly that.
Oh, I mean, to rioters who are after you, you should say, "Yeah, I shot someone, hurt me." He said what he needed to say.
Lukowski's testimony. And again, I think it's worth emphasizing at this point that Jason Lukowski had just met the defendant maybe an hour.
Hello,
This is about
Epic X.
11:50 at night. Mr. Lukowski got there about 10:45.
Look at their evidence. Look. What?
This is Gage Grosskreutz running towards danger, running to try and help.
Oh, the bloke that pulled a Glock on him. He's chasing Kyle, wasn't he?
This is exhibit number 3.
Nice exhibit.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody?
Right, Rittenhouse says I'm running to the police.
Listen to the second thing he says.
You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot?
All I heard him say was I'm running to the police.
It's hard to tell what his exact words are. I hear the word not
Ah!
in there, as in I did not.
You're going to hear the
shoot
word
anyone,
wanker a
not
lot
do
when you
anything.
go out.
Jason
That's
Lukowski, he
just
lies to.
rubbish.
The crowd, lies to. Gage Grosskreutz, he lies to.
Thank you, Tom. That's really
So at
appreciated,
this point,
mate. Nearly at 4 hours.
the crowd is dealing with what they perceive to be an active shooter. Someone who has just shot someone, who is still in possession of the gun, who is fleeing the scene.
And who is an absolute
How are
hero.
we supposed to know where he's going next?
Because he said then, I'm going to the
all
police.
night that night, the crowd has been hearing the sound of gunshots. They've been hearing fireworks, firecrackers. But now, someone actually has been shot. The crowd sees the defendant running with a gun. He's lying to them. He
So?
still has the gun. He's shot someone. This is provocation to them.
Oh,
This
is it?
Someone who has committed a criminal act and is putting people in danger. It is entirely reasonable for that crowd to believe at that moment that he is a threat to kill again. The defendant could have made it unequivocally clear what he was doing.
Because they're thinking very
Stayed
rationally.
at Mr. Rosenbaum's body, helped protect him, helped preserve his life, call 911.
Alright.
As
Yeah.
he's running, he could have announced to the crowd exactly what he was doing.
That's
Told them.
ridiculous.
He could have fired warning shots to try and keep him away.
The jury aren't buying this, people. Not a chance. This is such a reach.
Now that he did not pose a threat anymore. But everything he does is indicative of someone who is still a threat. Now, the defendant is going to tell you he wasn't. But from the crowd's perspective, how are they supposed to know any different? He does nothing to demonstrate to the crowd.
Even when he got to the police beef, he tried to hand himself in. They told him to stand away from the car and pepper sprayed him.
Turns out within a few seconds, he does kill again.
When he had a Glock held at his head.
I submit to you, ladies and gentlemen,
A Glock.
that in this situation, the crowd has the right to try and stop an active shooter. They have a right to protect themselves. The defendant is not the only one in the world who has the right to self-defense.
Oh,
What
that's
does the
fucked you
crowd do
up.
to try and stop the defendant?
Hit him over the head with a
I submit
skateboard.
to you, and this is not a criticism of them, but they use almost the least minimal, least intrusive means possible.
Kick in the head, skateboard wrapped
They
around the
could
head,
have
and a
used deadly
Glock.
force against him.
They did.
They could have shot at him.
They tried.
But instead, somebody comes up behind him and knocks his hat off. Anthony Huber comes up with a skateboard, and the defendant blocks it with his arm. And then the defendant falls to the ground on his own. No
Oh,
one knocked him down.
rubbish.
This man that the defense wants to call jump kick man. He's got no weapons, no gun, no knife, no nothing. Comes in and tries to kick the defendant in the face. Anthony
Yeah.
Huber comes back and tries to grab the gun. Actually does grab the defendant's gun and tries to pull it away because he's trying to disarm an active shooter.
It's not
Gage
active,
Grosskreutz
though.
comes running in, stops with his hands up in the air until he sees and hears the defendant adjusting his weapon as if preparing to fire again. And then what does Gage Grosskreutz do? He reaches for the gun to try and disarm the defendant. Gage Grosskreutz had his own gun in his own hand. He could have aimed it and fired at the defendant.
He did
but
aim
did
it.
not.
He got shot too quickly.
And you heard
prick.
Gage Grosskreutz testify about that, about how that is a decision that he was not prepared to make at that point
He
in
was
time.
too
He's not
slow.
the type of person who is just willing to take someone's life in an instant. Unlike the defendant, who took 2 lives that night.
Faster.
Very quickly and seemingly very easily. There is a video, Exhibit 5. Which
They
is
didn't
an
mention
EG
The
on
Rock,
scene
did
video,
they?
which traces this entire incident, which we call the second event. This is going to show you Mr. Huber, Mr. Grosskreutz, and the other individuals who are trying to stop an active shooter using what I would characterize as the least intrusive.
How do you
means.
define an active shooter? He wasn't firing then, was he? He only started firing again when they attacked him. You know, in self-defense. Yeah, can you imagine?
Someone knocks his hat off. Anthony Huber comes in with a skateboard.
Look how many people are after him. You're going to get killed. 1, 2, flying kick to the head, skateboard over the head. Hands up, Glock out, shot. Fuck you.
In just a few seconds.
He done
Defendant kills
everything.
1 person, attempts to kill 2 more, and blows off Gage Grosskreitz's arm.
And saves his life.
It's that fast.
Yeah, it's great.
This is someone who has no remorse, no regard for life.
You horrible
only
bastard.
cares about himself.
No, puts himself above others.
And these folks that are coming at him, the jump kick man, Anthony Huber, aren't armed. They're not a
Yes, he
credible,
was.
imminent threat to his life.
You just said he
They
was
are
armed.
trying to stop an active shooter. And they have a right to do so.
No, they want to
Imagine
kill him.
If the crowd couldn't do that. Imagine if they weren't allowed to try and stop someone in this type of situation.
I don't think they're buying this.
After killing Anthony Huber, after severely wounding Gage Grosskreutz, the defendant walks away like the hero, like he's some sort of hero in a Western.
What?
Without a care in the world for anything he's just done.
Like,
You know, it's
Carl,
interesting. This occurs about a block away from the police line, right down the road.
Which he goes
If the
to.
defendant's so concerned about his safety, the police are right there. And in fact, they pull up to this scene almost instantly.
No, they don't.
The defendant's got his medic bag on.
You're dreaming.
Claims himself a medic. He doesn't know at this point if Anthony Huber's dead or alive or capable of being saved. And yet the
Nor do
defendant
you.
offers no assistance, makes no attempt to
You're
try
a
and help
gun to
anyone
his
else.
head.
All he cares about is himself.
Good lad.
We have taken that video and we have broken it down into individual frames. And I want to take you through frame by frame the incident with Gage Grosskreutz, because a lot has been made about Mr. Grosskreitz's motions and what he does and where he goes and things like that.
And
So
what
I
he
think it's
said.
helpful for us to take a
And
look
what
at
he
this.
said.
So this is Exhibit 80, beginning with frame 356. At this point, you can see that Anthony Huber is staggering off after being shot in the chest. The wound has entered his lower left rib cage and has wound up almost exiting near his right shoulder. It has ripped through his ribs.
Shouldn't have
his
hit him
heart,
around the
his
head with a
aorta,
skateboard then.
And he may not technically be dead, but he's going to be dead within a few seconds. He is stumbling away. The defendant has the weapon pointed towards Gage Grosskreutz here, who is cowering,
No, he doesn't.
hovering,
Doesn't.
hiding, covering his head, trying to stay out of the way. And I'm going to go
There's-
frame by frame
there's
here
the
slowly
trajectory of that
as we
weapon,
see the
look.
movement. Now we see the gun is moving down towards Gage Grosskreutz. It is pointed directly at him from a distance of just a couple of feet. Gage Grosskreutz has his right leg planted as if he's pushing backwards, trying to get away.
Right,
The gun is still pointed at him.
right. Now the gun's lowering
The
as his
defendant here
arms
is
go
going to
up.
Adjust the gun.
Adjust it. Put
Turn
it
over
down.
as if he's making some sort of adjustment on it.
No, pointing
Gage
it at the ground.
Grosskreutz testified that this was a movement that he interpreted as the defendant preparing that gun as if it was going to fire again, as if clearing a jammed round so that he could shoot it at Mr. Grosskreutz.
The
At
gun
this point,
is now aimed at the
Mr.
floor.
Grosskreutz is, I think, probably thinking to himself, if I can get away, I will, until he realizes that the defendant is getting ready to fire again.
Look how many people there are hanging around this poor kid. I would have done exactly the same. And there he is, getting his Glock out. Carl Rittenhouse hasn't done anything. Now the Glock is out. And it's pointing towards Kyle. And Kyle thinks, I'm about to get glocked in the head. So he does the
In none
right
of these
thing.
frames is Mr. Grosskreuz's right hand with his Glock pistol pointed at the defendant.
Yeah, you're going to stop them and all, aren't you? All right. It is now. It is now. There it is. It's pointing at Rittenhouse more than Rittenhouse's
You can
gun
see
is
Mr.
pointing at
Grosskreutz is
him.
actually backing up with his
No.
right leg.
No.
Let me go back a couple of frames.
Ah, he actually went forward.
This is frame 444. You can see his right foot is on the ground, but it's starting to move back. Now, as I move forward in the frames, 447, his right leg is moved back. This is someone who is about to retreat. His hands are in the air. He's backing away from the defendant until, as he's testified, he sees the defendant start to manipulate that gun in such a way that it makes Mr. Grosskreutz feel like he's about to be shot. And only then does he take action. What action does Mr. Grosskreutz take? Does he hold that gun?
Look at
with both
Rittenhouse's
hands,
gun aiming down.
the Glock that he's got, and
Oh,
point it
you-
at the defendant?
You're
No,
stopping
never.
it there.
Does he even take the gun with one hand?
Yes.
And point it?
Yes.
No.
Yes.
Never.
Yes, he does.
Instead, you can see him start to lunge in with his left arm forward. The gun is not in this hand. The gun is in his right hand.
Why has he got the
He's
gun?
lunging forward, reaching for the defendant. Probably reaching for the gun. Probably trying to block the gun. You can see now he's going to take a step with his right leg across the defendant's body.
He's trying to
Not
get the
directly
gun.
towards the defendant, but across the defendant's body. As he's reaching in, almost swiping away at that gun with his left arm. He has bladed his body in such a way as to try and present as minimal of a target as possible, which is probably what saves his life.
A lot of problems
His right leg
in there.
is about
isn't
to
there?
hit the ground here. The gun, the AR-15, is pointed directly at him from just 2, maybe 3 feet away.
And the
He's
Glock.
trying to shield himself with his left arm.
I know. Why was he
And as we
there?
approach for frame 500 here, the gun goes off. At no point in this process is Mr. Grosskreutz pointing his gun at the defendant.
Well, that's weird because when he
Frame
testified,
499,
he said that
the gun
that's
is
when he
just
got
fired.
shot. Boom.
Frame 500, you see the puff of smoke. 501,
That
the
ain't
bullet
smoke.
has hit Mr. Grosskreitz's right bicep, severing it. I'm going to continue forward after this because you can see that
Saving
his right arm. This is an
Rittenhouse's
interesting
life.
frame right here, 504. You can see that gun. I'll go back even more. You can see that Mr. Grosskreitz's arm with the right hand with the gun, his right hand is pointed off to the side.
I agree,
What
Grego.
pulls that gun down closer to the defendant is the fact that Mr. Grosskreutz just had his right bicep severed. It's not a voluntary action. It's an involuntary, the muscle is severed. Now watch, frame 502, watch his right hand. 503, 504, 505, 506, 507, 508. At this point, yeah, absolutely. That right arm is probably dangling down towards the defendant.
Probably.
It's not going to be able to pull that trigger without
Hello,
a working
Patrick.
bicep muscle. And it's not a voluntary thing. It's done because the defendant just blew his arm off.
Blew his
But
arm off.
This is the time after the shooting when, yes, the gun happens to be pointed at the defendant.
Ah!
I'm going to stop here for a moment and highlight the hypocrisy of the defense. Because according to the defense, if someone has a gun, they're a threat. If someone points a gun, they're a threat. There's only one exception to that. The defendant. By their logic, he gets to run around with a gun all night.
They were chasing
we're not
him.
supposed to take him as a threat. He gets to point the gun at everyone.
He didn't chase anyone.
We're not supposed to take him as a threat.
Didn't chase
it doesn't
anyone,
work
did
that
he?
way. The same set of rules apply to the defendant as everybody else. There's no exception in the law for Kyle Rittenhouse. There's no exception that says if anyone else has a gun, you're a danger, except for Kyle Rittenhouse. There's no exception in the law that says if you point your gun at people, oh, that makes you a threat and I can kill you, except for Kyle Rittenhouse. I can do it all night long.
When
The
chased.
same rules apply to him as everyone else. And everyone else has a right to defend themselves also, not just the defendant.
Okay, so everyone's got the right to self-defense. Yeah, I agree. He's allowed to go free then. Great point. He just said it. He just said it. Everyone's got the right to self-defense. Yep, they have.
We have shown you photos and videos of Gage Grosskreuz's injuries.
Yeah, it's unconvincing. I don't think they're buying
Exhibit
this.
60 is a video taken right after Mr. Grosskreutz was wounded by the defendant.
He really just fucked it up when he said everyone has a right to self-defense. He absolutely fucked it up. There you go, King Corona. Stay strong, Carl. Well, that done nothing.
It's hard to look at.
Oh,
But
say
this is
isn't
what we're
it?
dealing with.
A killer.
When you fire an AR-15 at someone from close range, this is what it looks like.
Yeah, do you know what it looks like when you fire a Glock at close
I
range?
guarantee you, ladies and gentlemen, the defendant had no clue what his gun was capable of. He didn't even bother.
He grew
paying
up with
attention to it.
guns.
Didn't concern himself with what he would be doing to other people. But this is what happened. Let's not flinch away from this. It's important that we understand what that gun was capable of that night.
I think the
It killed two
prosecution,
people,
the defense,
and
going
it
to
did
rip this to
to
pieces.
Mr. Grosskreuz's arm.
A photo of his arm. This is desperate.
When those shootings occurred that I just played for you, what would a reasonable person in the defendant's position at that time think? The good news is, ladies and gentlemen, you're going to tell us.
Oh,
As
really?
part of your decision in this case, you will represent the reasonable person, of ordinary and prudent person, and you will put yourself in the defendant's shoes that night. I submit to you
At the
that
moment,
time of those
laughing, Brad.
shootings, a reasonable person in the defendant's shoes would have known that he had provoked Joseph Rosenbaum by pointing his gun.
By having a penis.
That the defendant had put someone else at risk of dying by doing that. The defendant should have known that the crowd was aware of the fact that he had just shot someone and that they felt their lives were in danger. That is reasonable.
Me too,
It is also
LC.
reasonable to understand that at that point, Gage Grosskreutz had just witnessed all of this.
And I think
He'd
you
heard
will.
The defendant had shot someone. He'd heard the defendant lie about it. He saw the defendant shoot at jump kick man at close range, miraculously missing. Had seen the defendant kill Anthony Hubert. Gage Grosskreutz reasonably believed his life was in danger at that moment. And he was proven correct because the defendant shot him too. So when you consider what's reasonable in this case, consider whether or not it's reasonable for a criminal to be able to shoot himself out of a crime scene. When a bank robber robs a bank and runs away and the crowd comes after him, can he just shoot anybody and claim self-defense? If someone comes up to that person and tries to stop them, tries to disarm them, like Anthony Huber did, do they forfeit their life?
Yeah, this is all
Did Anthony
bullshit.
Huber forfeit his life by trying to be a hero and stop an active shooter? Is that justified?
Yes.
Can the defendant just kill him?
And he testified that he didn't get shot until he pulled his gun on him.
In this case, the crowd was right. The crowd knew the defendant had just shot someone. When they're coming after him, they know he's just shot and killed Joseph Rosenbaum.
Exactly, Brad.
But you know, not every active shooter situation is the crowd have perfect knowledge. When they're told that person running up the street just shot someone, we don't have time in the moment to go back and take a look at the body and replay the video and make a decision before going after the person with the gun.
John, you can barely buy them, mate.
We've had
Most of
several
the
police
shops have
officers
sold
testify
out.
that in an active shooter situation, their first instinct, their first training.
Try
is
and
to
buy
go
one
in and
online,
stop.
John. You'll see most shops haven't got any
They
in
don't sit there
stock.
and wonder, well, maybe it was self-defense. I don't know. I'm gonna wait and see. And every day we read about heroes.
Come on,
It's
we
not
expect
active
this bullshit from the prosecution. He's got nothing to go on. He's been ripped
That's what was
apart all
going on here.
week. And he's just
And that
made a
crowd
fairy story.
was right. And that crowd was full of heroes.
BLM and
That crowd
Antifa.
did something that, honestly, I'm not sure I would have had the courage to do.
What,
if I see
burn-
a guy running up the
burn
street with an
America?
AR-15 and I hear he just shot somebody, my first instinct is not to approach. Anthony Huber was different. Jump Kick Man was different. Gage Grosskreutz was different.
Pedophile was different.
That doesn't make them a threat to the defendant's life.
It
It
does.
doesn't make their lives worthless. They don't give up their right to defend themselves.
Noddy
They have
Kyle.
just as much right as the defendant.
Excellent. So keep saying that. That's brilliant.
I told you I wanted to begin by talking about the murders committed by the defendant. Now I want to go back and put it all in context for you.
Oh, this
And
is
that
going to be
context starts with,
unbearable.
bruh, I'm just trying to be famous.
That's
The
not
defendant's TikTok profile. 4 doors, more whores.
awful.
Picture of him up in Ladysmith, probably in early May, proudly holding his new AR-15. Up until August 25th, 2020, this is the only time he'd ever fired that gun.
It's a fair
Maybe
point,
put 100
Giles.
rounds through it or so at that property up there with Dominic Black.
Oh, wow. He fired his
They
gun.
purchased that gun on that same trip. The defendant admitted he knew as a matter of law he could not buy that gun because he was only 17. Yet he wants to tell you that he thought legally he could possess it, which didn't make a lot of sense to me. We don't have a lot of defendants come in and say, well, I possess cocaine. I knew I couldn't buy it, but I thought I could possess it.
The judge isn't happy with any of
That's
this.
not the way it
Look,
works. Dominic Black conducted what we call a straw purchase.
judge not happy.
He purchased that gun for someone who was not legally allowed to purchase it for themselves. I'm prosecuting Dominic Black for that, as you know, just like I'm prosecuting Joshua Zeminski. Because what Dominic
Hello,
Black
Ian.
did was wrong. And we don't tolerate that. The agreement was Dominic Black was going to keep that gun until the defendant turned 18. It was Dominic Black's gun. It was legally his. And the defendant knew that it was going to be held onto until he turned 18, that he was not going to have it until that birthday. I want to focus a little bit on this AR-15 because I think it's important when you consider the
What a
recklessness
surprise.
of the defendant's conduct, how much he knew, cared, or didn't know about this deadly weapon. He'd only fired it that one time, maybe 100 rounds through it. He loaded the gun with full metal jacket ammunition. A little bit more.
As opposed
He wanted
to
it because he
what?
said it looked cool.
Oh, okay, Moslad.
Didn't seem to know or care much about the type of ammunition or the type of gun. You had a couple of witnesses tell us in this trial, and I could not believe it. A gun is a gun is a gun. Don't even start with that. A bullet is a bullet. No, it is not.
He
It
proved
is not.
himself
And
ignorant
anybody who
about
says that
firearms.
is ignorant.
No, you
and
proved
reckless.
yourself ignorant
Because
about
there are some important
firearms.
distinctions here.
And Rittenhouse knew
Full
more
metal
about the
jacket ammunition
law.
is capable of piercing body armor and squad cars.
So,
And you heard Officer Krieger testify that when they heard someone was running around with a rifle, he went and got his plate armor out of the back because their regular body armor wasn't going to stop those rounds. Ryan Balch talked about how full metal jacket ammunition is designed, and this is a former Army infantryman, is designed to go through a target like a deer or a person and continue on. He says it can hit a target 550 yards away. That's 5.5 football fields.
wow. Like what? Like a rifle?
And he explained that he had a handgun that night, which he put hollow point ammunition on. And that's what he was planning on using for self-defense. Because hollow point ammunition acts differently. It's going to hit its target, but it's not designed to continue on and go through and hit other targets. So you will hit what you hit, but you're not going to put the rest of the community at risk, especially on a night when there are hundreds of people out on the streets in a heavy residential area. We can see on that map, the car source, there are houses, there are churches, there are daycares, there are schools nearby, and you're firing full metal jacket ammunition.
Oh, they will do, Billy. Don't worry. This is expected. Come on,
I
this
submit
is
to you,
expected.
ladies and gentlemen, that AR-15 had no lawful or legitimate purpose that night.
Well, you're saying that about every
The
AR-15
Second
in
Amendment
America.
allows people to carry guns. That is true. There are people who can't carry guns, convicted felons, for example. But generally speaking, I'm not saying people don't have the right to carry a gun. What I'm saying is that AR-15 did not accomplish any of the goals that these folks said it was going to.
Oh, it did.
So, for example, Ryan Balch says the handgun is what he was going to use for self-defense. Several witnesses agreed you can't point this gun or shoot this gun at people to protect property. So if you're going to protect the car source building, how is this gun going to help with that? The defendant has admitted the gun was useless when he was going to treat people as a medic because it got in the way. He had to take it off and hand it to someone. So you can't use it as a medic. You can't use it to protect the building. So what's it there for? Well,
Protect
it looks
himself.
pretty imposing, and it has some deterrence value.
Protect
Jason
himself.
Lukowski, Dominic Black, and Ryan Balch all said they never actually intended to use their guns. So why is it there? The defendant was wearing a sling that night. He purchased that sling at Jelinski's that afternoon. The purpose of the sling was so the gun couldn't be taken away, wouldn't fall off, he wouldn't lose possession of it. It was designed to help him retain possession of that gun. And he loaded it with 30 rounds, the full magazine,
Oh,
capable
wow.
of killing 30 people or more.
Why wouldn't you?
Why do you need 30 rounds of full metal jacket armor to protect a building?
Well, he needed 3 to
This
save his
AR-15
life.
is completely incompatible with the role of a medic. Richie McGinnis testified he's been to demonstrations in Seattle, Portland, Washington, D.C., New York, Minneapolis. He's never seen anyone walking around claiming to be a medic with an AR-15. And certainly when you see someone like that, it doesn't exactly send a warm, fuzzy message. Oh, come to me. I'm here to help.
As unpleasant as this is to listen to, it's expected, and I don't think the jury are buying any of it. The jury also expect this. Binger is a dislikable person, and it's going to work against
The
him.
defendant was a fraud.
A fraud.
He was not an AMT. He lied.
Didn't say
He
he
lied
was.
to the press. He's being interviewed by Richie McGinnis, who he hears is a member of the media, and he says, I'm a certified EMT. You're lying. You're absolutely lying. Jason Lukowski and Dominic Black said the defendant had to borrow his medical supplies from us. This is an emergency situation. Everybody's anticipating violence. Everybody's prepared for people to be hurt, harmed, injured, and yet the defendant's going to go there and walk around claiming to be a medic? He's like a quack doctor practicing without a license. That puts lives at risk.
Oh, yeah, it's hard to put a
One of the
bandage
things
on
I
someone.
had Gage Grosskreutz testify about is that tattoo on his right arm, which said, "First do no harm, which is one of the precepts, one of the fundamental tenets of the practice of medicine. First, do no harm.
With his Glock. Second.
So how do we evaluate the defendant's performance as a medic that night? Well, on one hand, he wrapped up an ankle and I think to maybe help somebody who got a cut on their hand. Yay.
Fuck
On the other hand, he killed 2 people.
That ain't going
blew off
down
Gage
well.
Grosskreuz's arm.
No, he didn't.
And put 2 more lives in jeopardy. So, you know, when we balance your role as a medic that night, I don't give you any credit.
Awful, unpleasant.
He showed no remorse for his victims, never tried to help anybody that he hurt. And even on the witness stand, when he testified on Wednesday, he broke down crying about himself, not about anybody that he hurt that night. No remorse, no concern for anyone else. For him to call himself a medic is an insult.
Yeah, he cleaned graffiti off for his own good. Yeah, that makes sense.
The defendant made a series of reckless decisions that night, going armed with an AR-15 at 17 years old when he knew he shouldn't have done so.
That's
because
not
that
always
gun is
unfair.
normally locked in a safe that he doesn't have access to, and it's not even legally his. He's out after a citywide curfew. He's intentionally and knowingly entering into a dangerous situation, and he expects it because he brings along his AR-15 and some body armor. So don't tell me you didn't know. He brings along no non-lethal means of defense, which means his only option is to kill.
Lucky, really, or he'd be dead.
A lot of you, but I remember that night.
No, you don't. You weren't there.
I didn't come down here. I don't think most reasonable people did. In part, because we all knew
I had
it
to
was
say
gonna be
that.
violent and dangerous.
That's why he had an
Most reasonable
AR-15.
people, to the extent they came out, they were gone by then. Because you don't willingly put yourself in this situation unless you want it, unless you're looking for it,
Unless you want to look after.
unless you want trouble.
Unless you want to look after the area because you care about law and
Now, to put
order
this in
and your
perspective,
country.
At this time here in our community, there were people who were scared.
They will
There were
be,
people who were
Hooper.
worried about themselves, their homes, their families, their business. That's understandable. But this is different. There are also people out there who are exercising their First Amendment right to assemble and to have free speech because of whatever they believed in. And they have that right too. But that's not what we're talking about. The curfew,
He was a
the
cadet,
riots,
Grego.
the arson, the looting that we'd seen on those prior nights.
He was
roadblocks
learning
set up
how to
around
do it.
downtown, closed exits on the interstates. All of this was sending the message to reasonable people, go away. Don't come down here. Who was left at 11:45 at night? Most reasonable people had gone home before the curfew or never even came at all.
Ludwig.
But the defendant's down there, he says, because he wants you to believe he's protecting CarSource. Even though he had no actual ties or genuine concern for this
No,
building.
it's his country.
You know, this caravan of people from West Bend, Ryan Balch, Jason Lukowski, Joanne Fiedler, coming down from some other community, having no
Richard.
idea what's going on here, Kenosha, having no idea what businesses are, having never dealt with CarSource before, just injecting themselves into this situation.
Yeah, because it's his country. And he
Car
doesn't
source.
want exactly Woodlander. Exactly.
The owners testified. They moved all the cars off the lot. They took the tools out from inside, and they didn't even feel the need to protect that building.
All right.
So who's there? These guys with their AR-15s are just wannabe soldiers.
Ah!
Acting tough.
Ah!
Trying to manufacture some personal connection to this event, furthering their own personal agenda.
Oh, that's Carl Rittenhouse
Just a
all
small
over.
part of the deluge of chaos tourists we saw here in Kenosha, trying to feed off of what we were going through.
What were you going through?
Despite everything we did to try and tell them, go away, stay out.
We? What, you and the mass media? What, you and BLM?
Did those owners, Sam and Sal, ask anyone to protect their business? You know,
Doesn't matter.
called them to the stand because I wanted you to hear from them. I had their statement, but I wanted you to hear from them. And I'm sure you formed your own impressions about them. I'm not here to tell you that I believe what they said on the witness stand. I don't think it really matters much, except I wanted you to have a flavor of who these people were and what was going on at that building. What was interesting to me is that text message from the defendant to Sam asking for the address of CarSource, even though the defendant says he's already been there. It didn't make any sense to me. It's not hard to find if you've driven past there every day. You know, Kenosha is one of the easiest cities in Wisconsin to navigate. It's all east, west, north, south. How hard is it to find this place? But the agreement was the defendant was supposed to stay at the 59th Street location. There's another group at 63rd. It was their responsibility. And the defendant testified that when the shootings occurred at 11:45 or 11:50 at night, he didn't even know if that other group was still there or if they'd left.
He really is unlikable.
But crucially, you heard the testimony of Kriston Harris, who was out there reporting for his Rundown Live, and he's making some video. And he tells the defendant, stay on your property.
And his
Don't
father
go out
lived
the streets
there,
and engage with
Richard.
these protesters because you're just making it worse and you're escalating the situation. He tells the defendant specifically that. Just 20 minutes before the
Yeah,
shooting.
17.
Kriston Harris probably said that because he knows this is a crowd that is feeling threatened by the
Yeah,
defendant and his
I need to grab some food.
Richie McGinnis testified when he left the Stella Hotel and immediately ran over to 59th Street, he saw guys up on the roof and he felt threatened. These guns, he said, were the thing that changed the dynamic for him. Drew Hernandez, we showed video of Drew Hernandez having laser sights pointed at him. And he said he felt threatened. He thought someone was pointing a gun from the roof and putting his life in jeopardy. These are two people who are veterans. They've been to protests in Seattle, Portland, Washington, D.C., New York. They've been through this before. And yet here in little old Kenosha, the defendant's group made them fear for their lives. That's the kind of impact these AR-15s have.
Oh.
The crowd is yelling at the defendant's group. Stop pointing your guns at us. Stop pointing these laser pointers at us. And the defendant sees this. He's well aware of the fact that the crowd out on the street is hostile. They don't react well to him. And he knows that by 11:35 at night, this crowd is all the way down there south of 60th. That's where they're at. So if I go down there, I need to be prepared and I need to expect that these folks are not on my side.
He was.
Joseph Rosenbaum. He's dead.
Sorry.
So we don't know what he was thinking. We
Child
don't know what was going on in his mind.
Child
That makes him an easy target for the defense today because they can stand up here and pile on him and destroy his reputation, and he can't speak for himself. That happens a lot in homicide trials. Blame the victim who can't speak for themselves. So I'm going to tell you a little bit about Joseph Rosenbaum. And you've heard some
No
testimony.
way. He's going
In the
there.
hospital. Left it that day, had a clear plastic bag with his possessions, toiletries, a water bottle. We've all seen this. You get it in the hospital. It's pretty common. He's walking around like it's pretty much his only possession in the world. He visits Carrie Ann Swart, his girlfriend, and then happens to wander downtown into the middle of civil unrest.
Oh, come
No indication
on.
he planned to be there. No indication he's part of any sort of movement. He just happens to stumble into it. So what does he do that night? Oh, let me tell you all the awful things Joseph Rosenbaum did. He tipped over a porta potty that had no one in it. He swung a chain. He lit a metal garbage dumpster on fire. Oh, and there's this empty wooden flatbed trailer that they pulled out in the middle of the road, and they tipped it over to stop some bearcats, and they lit it on fire. Oh, and he said some bad words. He said the N-word.
He's disgusting.
If he were alive today, like Joshua Zeminski, I'd probably try and prosecute him for arson, but I can't because the defendant killed him. But that's the way we deal with people that do these things. When you commit arson, we prosecute you. We don't execute you in the street. And I'm not here to say that the things that Joseph Rosenbaum did were good or that I condone that kind of behavior. Not at all. But he didn't deserve to die for it. You can't kill someone for these things. He's 5'4", 150 pounds. Jason Lukowski characterized him as a babbling idiot. Lukowski says, I turned my back and walked away. This guy wasn't even a threat. I think we all know somebody like Joseph Rosenbaum, the Napoleon complex, the little guy who just wants to chatter. But when it comes down to it, it's all bark. It's no bite. It's like a little dog. Bark, 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 bark. But really?
This is the jury hate this bloke.
There is no dispute in this record that at no point that night did Joseph Rosenbaum hurt anyone. Never had a gun, never had a knife, never had a bat, never had a club. And in the Drew Hernandez video, that fight at Ultimate Gas that we showed you, he's being shoved around by the crowd like a rag doll. And yeah, he's mouthing off, he's talking a lot, but he doesn't actually threaten anybody, doesn't actually hurt anybody. They're pushing him around like he's a tiny little person, which, frankly, he was. And in the background of this video, you will hear somebody say, point your gun at me or something like that. That's Joseph Rosenbaum. He's upset because somebody pointed a gun and that triggers him, which is understandable. I think most of us would be triggered by that sort of thing. And that's what's upsetting to him. But he gets right in the face of people who have AR-15s. Never reaches for their guns, never rears back to punch anyone, never even lays hands on anybody. You're going to watch this confrontation here at Ultimate Gas, and I want you to keep in mind that there's a group of people on one side with AR-15s and a group of people on the other side. And none of the people with the AR-15s feel their life is in danger. None of them shoot their guns. They can handle themselves. The defendant can't.
America's finest.
That sound you heard was somebody throwing some sort of plastic thing at one of the stanchions underneath the gas station, and it makes a sound that almost sounds like a gunshot. So add that into the mix. You've got people with guns, loud voices, clear hostility, and the sound of something that, frankly, to me sounds like a gunshot, and yet everybody keeps their cool. Nobody hits anybody. Nobody fires a gun. And watch how they push Joseph Rosenbaum around like a rag doll. Watch this guy in yellow. He's going to shove Joseph Rosenbaum about 8 feet away.
Get away from me, pedo.
Well, I guess it was a different guy that did that. But they're shoving him around like a rag doll. Nobody feels threatened by Joseph Rosenbaum. He's not reaching for anybody's.
They're on the same
He's
side as him.
He's a little dog that barks. And you know what he's going to do now? He's going to tell him, hey, I need to go grab my bag. I don't have my bag. So they let him on through. There he is about to reach down and grab his bag off the ground. That's Joseph Rosenbaum.
I don't think this is going well for him
You've
at
heard
all.
testimony that he tells people
for the
"Shoot me,"
prosecution.
asking them to shoot him.
Nonce.
Curious how that's a threat to anyone else. He's triggered, as we saw in that video, by people pointing guns at other people, which is reasonable. Most people would feel that same way. And then we get to the crux of the defense, this threat that he supposedly made to the defendant. The defense would love to be able to play you a video of this threat. They would love for you to see it and hear it yourself.
Exactly,
This is a night
Lumi.
in which there are dozens of people out there, reporters and regular folks who are recording with their cell phones and with other cameras all night long. We have shown you video of almost every minute of the defendant's night from multiple different angles. And yet you have not been shown a video with this threat.
But the jury know that this bloke is trying to tell a different story to the week's evidence. They know that. They're not, people don't like being conned. They're not going to sit there going, oh, that's what happened. They know they're being conned.
We have his testimony, and what he says is there was an incident in which Dustin Collette had put out a dumpster fire and said something to the effect of, fuck around and find out. And Balch steps in, and he has an exchange with the protesters, and he turns around, and Rosenbaum is right there in front of my face yelling and screaming. And I tell him to back up.
Matt.
And he goes, you know what? If I catch any of you guys, blah, blah, blah. So that's the timing, according to Ryan Balch. Right after that dumpster fire. Kriston Harris from the Rundown Live.
It's so desperate,
Standing
Patrick.
right next to Ryan Balch. Not only was he there during the dumpster fire, but he stays with Ryan Balch.
You can still hear it, please.
Recording everything. And I've played this video for you. It is Exhibit 18. And I played for you a period of time from 1 hour and 22 minutes to 1 hour and 28 minutes.
Can you still hear it, people?
And I asked Kriston Harris, I call him to the stand, and I said, I'm going to ask you two questions. Number one, do you independently remember seeing Joseph Rosenbaum, hearing this threat? And he said, no. And then I said, okay, well, maybe you missed it because, there's a lot going on. So will you rewatch your video for me and tell me, is it in there? And he said, no. This video captures that entire period of time with Ryan Balch and the defendant right there, and there's no threat. There's no Rosenbaum. It didn't happen. The defense desperately wants this because they've got to give you a reason why it's okay to kill Joseph Rosenbaum. And this threat is critical to their case. But it's not there. In exhibit number 3, and I'll play it for you here as I'm talking. Joseph Rosenbaum isn't even visible. Now, I submit to you that even if, this is exhibit 18, even if there was a threat made, it's still not enough because Joseph Rosenbaum's unarmed and you can't kill him. But the defense has pinned a lot of their case on a threat that didn't happen and they can't prove. It's not on video. It's not there. So I'm going to pull up Exhibit 18, the Rundown Live video, and I'm going to go to that mark.
Yeah, yes, Globus.
Kriston T. Harris here to Rundown Live, and I'm here with a bunch of...
All right, Rex.
Kriston T. Harris here to Rundown Live. If you are live, share this in all your groups, your forums, start watching, protect the It's just like the year, man.
So here's the dumpster fire.
I can use a doobie right now.
Joseph Rosenbaum is not in this video. Here's Dustin Collette about to put the fire out.
Hey. Come on, reel in. Don't cause problems when there's not here. Yeah, that's true. Just stay on your property. I have to agree with her.
There's Ryan Balch standing right next to Gage Grosskreutz. Joseph Rosenbaum isn't here. And the defendant and his group are being told an important message. As long as you stay on your property, but don't go out there and cause trouble.
I have to agree with her. They shouldn't be on the street. They're just protecting their property. One of the guy's an asshole. I thought they were yelling at them. I was like, why no, no. One of the guys losing his patience has to go inside. Yeah, if you guys can switch them out.
He's talking to Ryan Balch right now.
He got a lot of rage. He said the wrong thing. This whole property is guy's life.
It's over, at least for now. The Fifth Circuit Court of Appeals has a...
This is where Ryan Balch goes and talks to a protester.
He's just trying to protect the property. He didn't know anything. He has no problem with you guys. He just allowing him to burn down his shit. I can't blame him.
I'm getting news that the Fifth Circuit has killed Biden's vax mandate. That's over for now. Biden's vax mandate is not going through. Hello, mate.
I know you are, but like, they got their own medics, and somebody's supposed to probably take care of them. I know you're just trying to make peace.
He's still going on, Lizzie. See you later, Alan. Yeah, but I can't listen to it, Rags. I'll give it a go.
I know, but like, when the conversations are having. Thanks, guys.
The rest of the video is the crowd being warded off by gas launched by the police. They launch tear gas, which affects the defendant, it affects Ryan Balch, it affects Kriston Harris. And that group all runs alongside the 59th Street car source, away from the street, away from any protesters. At no point in that video do you hear any threat that Joseph Rosenbaum makes. It's not there. Trust me. If the defense had it, they'd play it for you. Now, they want you to believe that that threat is made, and they also want you to believe that it was something that the defendant took into account when he decided to kill Joseph Rosenbaum. One of the questions that occurs to me is, how would the defendant even know who that guy is? Because earlier in the night, Joseph Rosenbaum is wearing a red shirt and a blue bandana.
Take care, Alan.
He's got no shirt on.
I got your message, Rex.
Blue bandana. This is someone the defendant has never even met before. He's one of hundreds of people in the crowd. And yet we're expected to believe that in a split second, the defendant remembers this guy? I don't believe so. So then that video that I just showed you leaves off at about 11:35 p.m. The police have moved the protesters south of 60th Street. They've tear gassed the crowd, and there's no protesters left. 59th Street is no longer in any danger. Wasn't much danger to begin with. Wasn't anything left there to protect. But by this point, there's no more danger. As law enforcement comes through, you've heard this video where they tell the defendant and his group, "We appreciate you," and hand them out bottles of water. As long as you stay on that private property, yeah. No one is saying you don't have the right to stay on private property and protect private property. What people are saying, what the crowd is saying, is stay there. Don't go out looking for trouble. The defendant hears this message from the police and takes it the wrong way. He thinks, oh, well, now I'm junior policeman. I can go run around stopping crime. But I asked him and I asked some other witnesses, If the police are there on the scene and the protesters are gone, go home. Why are you still here? You shouldn't have been here in the first place.
Turn
Why
that
are you
down,
still
Jess.
sticking around? And interestingly enough, one of the questions I've always had in the back of my mind is, what's the end game here? When is this crew going to be done and decide that it's time to leave? Well, right after the defendant kills Joseph Rosenbaum, kills Anthony Huber, and comes back, they all flee like rats off a sinking ship.
They're so bored with this bloke. You
But
did
it's
it,
boring.
Steve Turley, yes.
At 59th Street.
You did it,
There's no
Dr.
protesters.
Turley.
There's no action. So the defendant decides about 11:45
Yes.
p.m.
It is good news.
to cross the police line and go looking for trouble. He knows at this point he's entering a hostile crowd. He's seen this crowd. He knows what they're like. That's why he has to yell friendly to them, because he knows they're not going to see him and think he's friendly.
Oh,
And
the
he knows
same
he's
thing
got everyone involved
over
with
and
him.
over again.
Some sort of buddy to protect him. And he's immediately confronted by that man with the yellow pants who says, "You just pointed your gun at me." And the defendant says, "Yeah, I did."
And Steve, it just...
what's interesting to me is they
you
want you
can
to believe this
tell.
never happened. They want you to believe this guy in the yellow pants made it up or is lying.
Likewise,
He's just
Woodlander, I ain't got
standing
left
there,
much left in me.
business. When the defendant happens to walk up to him, do you think he just sat there and thought, "Oh, I'm going to make up a lie about this guy"?
Hello, Howard.
Moment, or did it really happen? And is it consistent with everything else you've seen about the defendant?
You
Does
can't
he
really
sound like the sort of
object
guy
to
with a
this.
pointed gun at someone
Unless he
standing
breaks rules, Beef, you can't object.
Does he strike you as the kind of guy that would threaten deadly force to protect property? Because that's what happened. The man in the yellow pants says it happened. The defendant agrees. And then he comes into the trial and says, "Oh, I was being sarcastic." Like he's a little 17-year-old and he wants to get out of it. Shortly after that, the defendant loses track.
I
His
cannot.
protector.
It's nearly 5
Ryan
hours, Loomy. I think I'll knock it on the head
So
at
now he's in a
5.
position where he knows that he's
You're all right,
surrounded by people
Rags. Strontium
considering
dog.
him a threat.
Exactly, Albert.
That
That's
he's
a
not
great
supposed to go
point.
anywhere without Ryan Balch. He knows he's supposed to go back to 59th Street. And he does. He tries. He walks up to the police line. He says, "I work there. That's my business," which isn't true, but whatever. And they won't let him through. Now, Ryan Balch makes it on through shortly thereafter, but the defendant gives up. He could go one block in either direction and make it back easily if he wants to.
Everyone
He
else
stops
can
and decides,
see
"You
the
know what, I'm gonna stay
Woodlander
here."
Rex. I don't think there's an issue
Let's
there.
see what's going to happen.
If he is fake, he's
So then
saying
he talks to
things
these
that the
people who follow
Woodlander
his
always
He's
says
going to go down to 63rd Street.
that are harmless
Yes,
and
one of them
friendly.
come
So it's a weird
say
troll.
Now, at this point, doesn't have Ryan Balch. He knows he's supposed to go back. He knows he's supposed to have a buddy. And yet he decides to go it alone. He decides to run down to 63rd Street or walk down to 63rd Street. Doesn't even know if that other group is still there. Doesn't even know if he's really needed. But he can't wait to take this opportunity to go down and confront people.
You know, the ones who were chasing him.
Some sort of junior cadet who's out there with the responsibility to fight crime. Nobody asked him to do that. Nobody gave him the right. Nobody deputized him.
Yeah, they did. The
Ryan
Second
Balch
Amendment.
says, "The police told me the crowds, we're going to push them down by you. You're going to deal with them." The Bearcats hand out water and tell him he's appreciated. As he's crossing the police line,
I'm sorry to stop it for a moment. I'm not sure many of you will be too bothered. This has been like 2 hours of him saying the same thing. He's just said the same thing in about 100 different ways. And as much as it's painful to hear, because it's just lies, I don't think the jury are buying it. I think they're bored. They you know, he's made his point 1,000 times. And that's what you do when you're lying. You know, when you've got the truth, it's very easy. It's very quick. You only have to say the truth once. But when you're lying, you know, you see when children lie to you, they just keep saying it. And no, this is what happened. No, I've done that because I had to do that because, you know, because of this. And it's like, all right, yeah. But when a kid tells the truth, he says, no, this is what happened. And I as painful as it is, because he's casting someone that we all respect and believe as a villain, this isn't a great final statement.
you are here to decide whether or not his actions are legally justified, not
See you later, Charlie. Thanks for hanging out.
Excuses that might be
Feel free to chuck something into
As
the
a teacher,
grift,
when a
people.
student says
5
to you,
hours.
"The dog ate my homework," that's an excuse.
Go
It
inside.
doesn't get you out of the homework assignment.
Haven't even eaten.
If you panic in a situation that is not reasonable, that is an excuse. It is not a justification.
Bowl of
If you're
noodles.
17, if you don't have training or in a situation where you're in over your head, if you're scared, those are excuses. Those are not
Mate.
legal for your own
Oh,
actions.
that was a bit scary, wasn't it? See you later, RMF.
The court has read to you the instructions.
Take
in this
care,
case.
mate.
They lay out the law that you should apply. That reading took a long time, and I understand there was a lot to digest. And one of the things that you will have the opportunity to do when you go
no,
back and
but
deliberate is read
you
through
are
those
saying some
instructions yourself.
peculiar things today.
I get that listening to them
I
doesn't always
mean,
make it
Woodlanders,
But I encourage you to
Woodlander,
focus
and
on some things when
I
you
don't
consider the
understand.
defendant's
Maybe he
convictions.
blocked you.
You are told that criminally reckless conduct is conduct that threatens other people's lives and poses an unreasonable and substantial risk to other people. There is no dispute the defendant's activities here threatened other people's lives. He took 2 lives. You know, this is not like a normal murder case. A lot of murder cases where I'm here trying to convince a jury that the defendant killed somebody. That's not a dispute here. That's the easy part. The question is, does he get a pass? Do we think that's okay?
Yeah.
Do we think what he did was right?
Yeah.
That's the question you have to answer. And when you consider whether his conduct was criminally reckless, consider, did it pose an unreasonable and substantial threat to the safety of others? Count 4 charges him with first-degree intentional homicide of Anthony.
Agreed, Albert.
There is no doubt that the defendant intended to kill Anthony Huber or committed conduct that he
I know.
was practically certain.
Everyone knows that, Rex.
That gun was pointed at Anthony Huber's lower left rib cage, and the defendant deliberately pulled the trigger. That was no accident. And when you do that with an AR-15 against someone's body, it is practically certain to kill.
Which is handy when you're trying to defend your life.
We all know this case comes down to self-defense, but there's a high bar for using deadly force in a self-defense situation. The law says that the defendant may intentionally use force, which is intended or likely to cause death or great bodily harm, only if the defendant reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. So did Joseph Rosenbaum pose an imminent threat of death or great bodily harm to the defendant?
Yeah.
No way. Did Anthony Huber pose
Why was he
an imminent
chasing
threat
him then?
of death or great bodily harm to the defendant? Absolutely not.
So are you suggesting a human can't cause great bodily harm to someone just because they haven't got a weapon? Well, that's ridiculous. You could have smashed his head up and down on the tarmac 10 times and killed him. So if these people, as I've said countless times, everyone who didn't chase Carl Rittenhouse or try and attack him is still alive. Simple.
Under the circumstances that existed at the time of the alleged
Thank
offense,
you, Rags. Much
the
appreciated.
reasonableness of the defendant's beliefs must be determined from
Nice
the
one, Skin
standpoint of the
Scar.
defendant,
I'm hanging
at
on by
time
the
of defendant's
skin of my
acts,
teeth, to be
and
honest.
not from the viewpoint of the jury now.
Thank you,
So
Rags.
put
That's
yourself in the
appreciated.
defendant's position. Would you have done the same thing? Would a
Yep.
reasonable person have done the same thing?
Yep.
Would you have engaged in the reckless conduct that led to this course of events?
No.
Would you have gone out after curfew with an AR-15
Yes.
looking for trouble?
No.
Would you have aimed at other people? Would you have tried to use the gun to protect an empty car lot? No reasonable person.
Yeah, I would have looked after my town if the communists were
The court
burning
has
it
also
down.
instructed you on provocation. You hid behind self-defense if you provoked the incident.
The bloke
If
that was
you
chasing
created
him.
the danger, you forfeit the right to self-defense. By bringing that gun, aiming it at people, threatening people's lives, the defendant provoked everything. And if he does that,
Rittenhouse looks
he has to
terrified.
exhaust
Poor kid.
all reasonable means to avoid a confrontation. All reasonable means.
Thank you,
So
Aramas.
Joseph
Very
Rosenbaum is
kind.
running at him. Joseph Rosenbaum is no threat to his life. And not only is the defendant expected to yell, push, shove that rag doll around, run back for help, call 911, do all sorts of other things besides just turn and fire 4 shots as Joseph Rosenbaum falls helpless to the ground. Ladies and gentlemen, there is no doubt in this case that the defendant committed these crimes. He committed a first-degree reckless homicide against Joseph Rosenbaum. He put Richie McGinnis's life in jeopardy.
Nice one, Raw Dog.
He put Jump Kick Man's life in jeopardy. He intended to kill Anthony Huber, and he attempted to kill Gage Grosskreutz. All of those elements are true. The question is whether or not you believe that his actions were legally justified. And I submit to you that no reasonable person would have done what the defendant did. And that makes your decision easy. He's
Such a
guilty
ridiculous thing
of
to
all
say,
crimes.
wouldn't it? Strontium Dog.
Thank you.
Fuck you.
Thank you, Mr. Mayor. Let's take a break and about 2:25, hopefully. And please don't talk about the case. Read, watch, or listen to any counter trial.
Yeah, I felt a bit like that, Hayden. I mean, just sitting there having your character torn to shreds by a professional piece of shit. Not nice at all. Fair play to Rittenhouse for keeping it together. I would have liked to think I would have done, but at that age I was a bit off the wall. I wouldn't have been surprised if I'd have stood up and said, fuck you. And grabbed that AR-15. Wrapped my smuggled in mag into it and said, I'll show you what homicide is. Eat this, Binger. Nice one, Barney. Very kind, very kind. Much appreciated. I haven't got a lot left in me, though, people, to be honest with you. We'll have a nice little chat now. You're going to get to see me eating. I've had nothing. I think I had some fruit. Did I eat? I think I might have had a full English, actually. It's so long ago, though. I'm a bit... Well, actually, you don't need to see me eating that close up. With noodles, you know, it's a bit much. But I really felt for...
No, you could have gotten away with murder because I wasn't timing it. After having, you were. How long did you talk?
He talked 2 hours and 8 minutes. I can give the exact starting time.
What's that?
I said I can give the exact starting time.
Well, why don't we call one of the networks and they can tell us because. What? So, well, let's get everybody under oath and work it out, and if necessary, we'll have a hearing on it.
So it sounds like he took the piss with the time. The judge is just laughing about it. Come on, mate, wake up. There's a kid's life at stake here. But, and I'm no legal expert, if I was the defense, I wouldn't want 2 hours. I'd try and get that over in 30 minutes. I'd just tell them what they saw. Just tell them what they saw on the videos. Well, at least we didn't get. It's actually just some packet noodles. But my missus is pretty good at knowing the good ones, and they're actually very nice. But they're fucking spicy. It's making my nose. Make my nose run. Anglosaurus Rex series. No, I don't know what you mean anonymously. You're going to have to use a card, whatever you do. So if you don't want to use a card, I don't think you can do that. It's all right, man. No worries. You know, if you've got concerns around your anonymity, it's all good. But, you know. So what do we reckon, people? This will be the final one, because I'm not afraid. I've got to get some sleep. It's, you know, nearly 4 o'clock in the morning here, and I have not stopped today. So let's have a final poll, shall we call it? 1 in the chat if you think he walks. 2 in the chat if you think he's going to get locked up. 1 in the chat. Oh, don't say that, Raw Dog. It should work. People have been donating, but no worries. Thanks for trying anyway. That's a damn shame. Actually, Entropy is not even up and going. Did you try Entropy, Raw Dog? I'm just signing in again. But no worries. You know, that's annoying. But I'm just signing back into Entropy, so it should work. Or did Super Chat not work? Fucking annoying, these bloody things, when people actually try and give you some money and they can't. Fucking hate it. Well, Entropy is back up and running. Hello, Moody Edge. Good to see you. You don't need sleep, Danger. You're a machine. Well, I try and give that impression, but trust me, I really do. I'm shattered. I started work at about 11:30. So where are we going with these numbers? A lot of 1s. Yeah, I get. It's weird you say that, Raw Dog. I get a lot of people say that they've tried to donate, but Entropy should be all right because it doesn't go through YouTube. Yeah, this is my concern, actually, Jack. Are people saying 1s because they believe he's gonna get off, or are they saying 1s because they want him to get off? You know, that's the concern. Nice one, Al. That's appreciated. Great stream, mate. You've done your bit. If you need to sleep, yeah, I'm gonna just eat these noodles and chat to you while I eat them and just calm my heart down a bit. Moslab says, 1, I just need to believe in our judicial system or the world is doomed, not just the USA, the world. Well, you know what, Moslab, this is why I've been talking about the USA so much recently, and I know a lot of people get a bit funny about that, but it affects everything. What happens in America affects everything. Nice one, Old Malt. See you later, mate. Thanks for hanging in. Albert thinks we're going to get a hung jury. That's very kind of you, Raw Dog. If it doesn't work, it doesn't work. You know, thanks for trying. Hello, Mega Essex boy. Good to see you. We ain't got. I mean, it's not. Oh, Loki's joined the Scrubs Telegram, I'm guessing. This whole idea that Rittenhouse went down there to shoot people, I hope the defense addresses that. You know, it's just a one-liner. If a man with 30 rounds in his magazine went to the riots to shoot people, he would have shot more than 2. And he certainly would have shot them without them needing to chase him. That's just that whole 2 hours disproved. The whole of that prosecution was about he went down there to kill people. Well, it's weird that he only killed people who smashed him around the head with a skateboard and held a gun to his head. You know, and if that weapon is so powerful and so dangerous, well, he didn't do much killing, did he? With 30 bullets, good lord. It's almost as if he only killed people that tried to attack him. Which, weirdly, is called self-defense. All right, no worries, Raw Dog. I appreciate you trying. That's very kind. What a terrible shame. Raw Dog, try Entropy. I feel like I'm hassling you now, but Entropy, the link is at the top of the super chat. You can always try that, and that way you don't give YouTube any money either. Entropy is legit as well. I've been, you know, they're a really good company. That's very good of you trying again, Raw Dog. That's really kind. Sorry, I don't. Eating it like a local. Well, what the locals will do is get chopsticks, hold the bowl to their mouth, and just pile them in. They just go like that. Dun, 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 dun. But hello, Michael. No, it was just it might have been ant flavored or something. It's burning my mouth to pieces, and my nose is running as well. I mean, look. I agree with you, Moslab. You know, America is the reserve currency of the world. America protects the world from the neo-Soviets and the Chinese. If America falls, what do you think is going to happen? The Chinese and the neo-Soviets will take the role of America. There's a global hierarchy. Someone has to be at the top of it. That's just how it is. Unless you're a communist or a globalist, and I'm guessing most of you aren't. So someone has to be at the top of that hierarchy. And they kind of pull the strings on military and economy. And if it ain't America, it's going to be China. And if it's China, that includes the neo-Soviets. I think that's a terrifying situation to be in. And thankfully, I think we'll see this administration kicked out of this situation, kicked out very soon. The midterms will be the start of it, and then they'll lose most of their power. I'm just refreshing my entropy, Rags. No, nothing there yet. Good Lord. Maybe, I'm just wondering whether YouTube and Entropy and all that are struggling tonight because so many people are watching this. Al, I sent you a super chat. Yeah, I thought I read it. Sorry, mate. Maybe I read it when I had the sound down. I've just seen it in Entropy. There you go. That one, Al? Great stream, mate. You've done your bit if you need your sleep. Was that the one or another one? Let me know, Al. There's nothing going on. There's nothing going on in the court. They're on a break. Bitcoin is anonymous if you've got Bitcoin, yes. No joy on entropy. What an absolutely what a terrible shame. Raw dog. Raw dog. There you go, mate. That it's on the screen. Raw dog just put £3 into entropy. I bypassed YouTube finally. Keep it up, my bro. There, look. I didn't get your one come through, Rags, but it's all right. You know, these things are problematic. Wait, stop me. Is it possible to get on crypto with no form of ID? No, quite the opposite. Buying crypto these days, they want passport, they want photo of you holding your passport, they want all sorts of things. I mean, they always did. When I first got on the dark web in 2011, I think it was, on the first Silk Road, you know, you had to jump through all kinds of hoops. But once you got your account, it was anonymous. But you had to get on there. Right, people, I am going to play some music as I always do at this stage. The transactions are, but to buy some, you know, you can't just say, Rex, you can buy bitcoins off of people in the street. Go to localbitcoins.com. And then you tell them where you put in your area and you can hook up with someone. They'll meet you in the street and put it on your phone. You don't need to tell them your name or anything. But no one's gonna give you bitcoins if they can't prove, unless you're going to give them the money first. So there has to be a certain element of trust established. And to do that, you go through something like, who do I use? What are they called? Blockchain.info, I think. I think it's time for a bit of cold hard steel. Good Lord. Where did my day go? It's been a right laugh, though, people. It's a bit of a shame I can't stay up for the defence. I'll watch that the minute I wake up tomorrow so that I know where we are for the morning stream. People who ain't usually here, I stream twice daily, usually about 8:30 in the morning and then about 4:30, 4 o'clock in the afternoon. Unless my missus is here, then it's just once a day. Oh, I nearly blew my ears out then. And then it's just once a day. But whoa. Thank you, Melvin. Much appreciated. Are you actually down in Catford with that fucking big black and white cat at the market? Amazing. Absolutely amazing. We'll have a bit of that. I'm going to turn that down and not blow my ears out like I just did. I'll turn it up over there. Listen, thanks to Rags and Moslab for looking after the place. Thank you to everyone who hung out. We did get to 210 at one point, but it's been 5 hours and 8 minutes. So massive respect to all of you. Thanks to the people who donated, and a special thanks to everyone who, I mean, at one point we needed to slow the chat down, and that's amazing. So how nice to be able to, you know, look at this stuff, discuss it like adults, have different opinions, and that's all good. And I think, you know, when you've just got a few hundred, it's a perfect number because you do get your comments put on the screen. You can share some jokes. You can share some interesting points. The chat's not just zooming up like nobody's business. So I see this one as a success. Hang on a minute, Rags. I'll have another look. I mean, sometimes it takes a payment but doesn't show it, which is a bit annoying. But let me see if I just update it. But doesn't show it, which is it looks like it is just showing raw dogs. No, nothing there, Rags. Look over there. Look. But I'll check in the account. I can't check in the account when it's open like that, but I'll check in the account, and if it isn't there, I'll talk to the people at Entropy and get that back to you. But nice one for trying. I hope you enjoyed the stream, people. This is, I'll put your final comments on the screen, and I'll see you all at 8:30 UK time tomorrow morning. And sign up to my Substack, link in the description. And don't forget, apparently, Biden's mandate has been booted. Lovely. Play the music. I am a bit behind now. Oh, it sounds like there might be something happening. Look at my computer, I can't even stop the music. There's something happening, people. Well, we'll go through these.
Attorney Richards has it as 37 minutes. I have it as 32. So I don't think it's 2 hour, even with his timestamps, it's not 2 hours and 8 minutes.
Well, look, I actually wouldn't have strictly enforced it. I was going to make my usual statement, but I won't because someone will accuse me of being biased against my own religion. But I usually have been quite permissive about this. I set very strict rules, and then I'm somewhat indulgent. So I probably won't call anybody about it. But so you can both talk for 8 hours. Okay, yeah, we got it.
Right, the defense is starting. People, I've got to go. Enjoy. I'll see you tomorrow morning. Ta-da. I won't bother with the music, so I imagine you want to watch this. See you later. Ta-da.